And on that count, time spread.
Much of.
Needful in 2 weeks.
I am for the petitioner, my lord.
They appear for respondent number 3.
But the matter relates to ranking assigned to the third respondent. My lord, this is also relating to the issue of Rule 3B of General Recruitment Rules, my lord, that rural weightage. That the third respondent was initially appointed as a sub-inspector, under the rural weightage, my lord, on 4/1/99. My lord, pursuant to the judgment of the Honorable Supreme Court, my lord, his services were terminated on 11/7/2003. Thereafter, my lord, pursuant to the special absorption rules that were framed, my lord, he was once again appointed on 21/11/2003. Lord, on a representation made by him, Lord, stating that one of the candidates who has been appointed under the category 1, my lord, has been given sub-inspector civil. My lord, he was once again, my lord, granted the benefit of seniority from 4/1/99, my lord, though his services were terminated pursuant to the abolition of rural weightage, my lord.
No, what does the absorption rule say?
Absorption rules specifically say, my lord, that the appointment would be from the date prospective, my lord. That appointment order I have produced, my lord. Your lordship may kindly see the order dated, my lord, page 98, my lord. Page 98.
2014, what you are 2019, you are challenging it.
My lord, that order was passed in 2017, my lord. The lordship will get the order.
Where is that absorption rule?
15/3/2019 is the order under
Okay,
challenge.
where is the appointment order?
My lord, page 98, my lord.
The appointment of sub-inspector.
This is the appointment of third respondent, my lord. Kindly see the first condition, my lord.
Leave and pension but shall not be considered for it. So you say pay shall be fixed at minimum. Yes.
My lord, it specifically says that, my lord, he shall not be considered for
Pay and senior.
Pay and seniority.
Yes.
Now, my lord, he makes a representation on 12/7/2006. My lord, that is at page 104. My lord, by this, my lord, he says that one Mr. Mudduraj, my lord, who was appointed in 2005 pursuant to revised select list. My lord, he was appointed initially in the reserve sub-inspector cadre at category 1. Subsequently, on a representation made by him, my lord, he has been shifted to, my lord, sub-inspector civil. And therefore, that post having become vacant, my lord, the third respondent made a representation stating that his claim has to be considered against the vacant post that has occurred under category 1. Lord, ignoring the termination of the third respondent and, my lord, subsequent appointment pursuant to the absorption rules, my lord, he was appointed to that post. Retrospective from 4/1/99 once again.
Where is that?
Lord, that is at page 110, my lord.
What does the tribunal say?
My lord, tribunal, my lord, initially, my lord, set aside this order and then proceeded to, my lord, hold that he is not entitled for reservation. My lord, that order was challenged by one Mr. Srinivas before the High Court. My lord, the Srinivas, for what reasons, my lord, he withdrew that writ petition. Subsequently, my lord, I approached the Honorable High Court Tribunal, my lord, challenging the seniority of reserve sub-inspectors, my lord, reserve inspectors, my lord, in application 5990 and 94 of 2012. Noticing the tribunal, my lord, noticing that he could not have been extended that benefit, my lord, by way of an interim order, my lord, page 235 may kindly be seen, my lord. 235, my lord. My lord, your
Is there
lordship,
an interim order?
yes, my lord, your lordship may kindly come to page 236, my lord. Last
What has to be
paragraph,
heard?
my lord, last paragraph, my lord. Last paragraph, my lord, in addition to, your lordship got it, my lord. In addition, the learned AGA representing respondent 1 and 2 is directed to examine as to whether giving seniority to respondent 3 to 5 on the basis of their initial appointment in the year 99, which appointment has been cancelled in pursuance of the quashing of 3B of the general recruitment rule by the High Court, which decision has been approved by the Supreme Court subsequently on the same point, amounts to contempt of High Court and contempt of Supreme Court, so that this tribunal can decide as to whether, as reference has to be made to the High Court and Supreme Court for considering the question of contempt of court in this regard. Lord, pursuant to this, my lord, the authorities having come to know that there is
We'll hear it. We'll hear it. Get ready. When will you get ready?
Lord, any day, my lord.
May I make my submission? I appear for respondent number 3.
One moment, my lord, your lordship may kindly see annexure L page
Wait,
27.
please wait. Mr. Vijay Kumar, wait.
The issue relating to my retrospective conferring the benefit of seniority is not before the court. It was not before the CAT.
Lord, that interim order itself shows, my lord, that there is an error committed and therefore they have proceeded.
I did not interrupt my learned friend. I don't know. Annexure A13 was shown to the court. May I request the court to kindly come back to annexure A13, which was referred to by my learned friend.
And Professor, we'll hear this next week. Let the government advocate get the records and let him get ready.
Now that the learned petitioner's counsel has substantially made out his case, I will just show.
No, we'll hear it. No, we'll hear it next week. We have got a basic idea of what the dispute is.
Yes. No.
So we'll hear it. Let the government also
precisely
come
why I should be heard, because only one side of the case is only one version is
No, we
shown.
are not determining anything.
No. Otherwise, material aspects are not placed before the court. That order has become non-est.
Right.
It is non-est.
Professor, we are not deciding anything today. We are simply adjourning it. Let the government advocate get the records.
No,
Yes.
Getting only one version should not impress the mind of the
No,
court.
it will not impress the mind. Rest assured.
It should not.
No bias, no opinion formed.
My learned friend is very good at it. I thought I should place all the material.
I am ready to place. I have already placed all.
At least I think my brother will vouch for that. We don't pass orders without hearing.
I will only
We
show.
hear in detail and pass orders. Our disposals may be slow, but our orders are.
No, this is a pure question of law. If I may say so with respect, it's a pure question of law. Matter may be heard.
We'll hear.
This week
Matter
itself.
has to be heard. No. Because vacant stay application is filed. Yeah, I heard the petitioner just to know whether the application can be considered independently.
It
Now
can
that
be.
after hearing him, matter has to be heard.
No. That is precisely why I said. No, the application may also be considered because the question of it's a pure question of law.
Yes,
that is
yes,
the case.
Yes.
And it needs
so
to
because
be.
hearing you on the vacant stay virtually
amounts to hearing.
The writ petition itself. We'll take it up next week. Yes.
In the meanwhile, there is serious prejudice caused to me because of the interim order that has been granted.
Matter is already, I think, 2015 years old.
Because of the pandemic situation,
yes.
We have suffered.
We'll try to do it next week. Yes.
Any date may kindly be given, madam.
Yes.
I am appearing for some applications there. Any date may kindly be given during.
Yes, the next week, the first. First 1-3. 1-3 holiday. 1-3 holiday.
ಅಲ್ಲ ಫಸ್ಟ್ ರಜೆ ಇದೆ ಈ ವಾರಲ್ಲೇ
ಶುಕ್ರವಾರಕ್ಕೆ ಹಾಕೋಬೋದ ನೋಡ್ಬೋದು.
ಬನ್ನಿ ಬನ್ನಿ 2ನೇ ತಾರೀಕು ಬನ್ನಿ.
1ನೇ ತಾರೀಕು ಶಿವರಾತ್ರಿ.
What is the affidavit? What is matter about it? Wait. Let us receive it. Yes. Sorry.
Can I make a request, my lords?
Yes.
My lords, I am appealing for impleading applicants. A copy of the affidavit also may be served on me, my lords, because
Wait.
ultimately my rights are, my
You have
lords,
not received a copy.
I'm
We are
sorry.
yet to receive a copy.
I'm
Yes,
sorry.
it come into our hands, then you can apply and take a copy.
I'm sorry, my lord.
ನಾವು ಸ್ವಲ್ಪ ದಿನ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದೀವಿ. ಬರೀ ಶಾರ್ಟ್ಕಟ್ ಎಲ್ಲ ಬೆಂಚೇ ಮಾಡ್ಬೇಕು. ಎವ್ರಿಥಿಂಗ್ ದ ಬೆಂಚ್ ಹ್ಯಾಸ್ ಟು ಡು. ಗಿವ್ ಯು ಕಾಪಿ, ಕರೆಕ್ಟ್.
ಅಲ್ಲ ನಾನು ಇನ್ನೊಂದ್ ದಿವಸ ಹಾಕೊಳ್ಳಿ ಅದು ಪಾಸ್ ಅವ್ರ ಬದಲು ನಾನು ತಗೋತೀನಿ, ಇನ್ನೊಂದ್ ದಿವಸ ಹಾಕೊಳ್ಳಿ.
You have a advocate's clerk. No, even the clerk should not be bothered.
ಅಲ್ಲ ಇನ್ನೊಂದು ನಾಳೆ ನಾಳಿದ್ ಹಾಕೊಳ್ಳಿ, ಅಷ್ಟೊತ್ತು ತಗೋತೀನಿ ಅಂತ ಹೇಳಿ.
Let us first receive the
Please.
Next.
My lord, I appear for the petitioner, my lord. Your lordship may remember this matter was heard on the last occasion because the tribunal has directed to continue the inquiry even though the statutory time limited at 214 is over, and this is a matter related to disproportionate income where matter is covered by Kempaya's case. The Lokayukta under section 7, my lord, cannot hold an investigation, and consequently. Last occasion, your lordship directed articles of charges whether served even today because it's the incident of 2014, and the tribunal, my lord, directed the inquiry to be continued. But the articles of charges as on that day, even today, it is not served, is my case.
Play the record ಬಂದಾಗ ತರಬೇಕು. Arbity, I find it strange. Your client is situated across the road.
Yes, well.
What is this? We'll pass it over, get it.
Pass over.
Not anything adjourned.
Madilanta, I have made a positive statement.
Yes,
Till today it is not.
pass over. He says it was sent and you refused it. I post and you have refused. ಯಾವ್ದೋ ಒಂದು
Appear, my lord. This is an unfortunate case. An officer has been subjected to an order of suspension for having acted against an official against whom complaints were given, and for having given a report to the higher officer that there is a complaint received. She has been suspended. Kindly come to the facts of the case, my lord. Applicant was working as a deputy controller of legal metrology, my lord. My lord, a complaint was received from as per annexure A1, my lord, that certain persons in the department are involved in that is joined hands with the petrol bunks under and weights, and they are defrauding the department, my lord. As against that, a detailed video was also sent, and then the concerned complainant, one Mr. Pillaya, the editor of Ukra News, my lord, he gave a complaint saying that action may be taken. This complaint was addressed to me, my lord. Kanun ka mapana upa niyantrikaru. I am a deputy controller. Then, my lord, I having received this complaint, my lord, as per the government order, my lord, if a complaint is received, then, my lord, concerned officer should take action immediately. That is the requirement. Annexure A7, page number 85. Because I have acted only according to the government instruction, my lord. Government says that if there are page number 85, annexure A7, my lord. If a complaint is received against an officer, what should be done? ದೂರುಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟ ರಿಜಿಸ್ಟರ್ ತೆಗೆಯುವ ಬಗ್ಗೆ ಕಾನೂನು ಮಾಪನ ಶಾಸ್ತ್ರ ಉಪನಿಯಂತ್ರಕರು ಸಹಾಯಕ ಹಾಗೂ ಇವರ ಮಧ್ಯೆ ಅಂದ್ರೆ ಉಲ್ಲೇಖ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಸಾರ್ವಜನಿಕರಿಗೆ ದೂರುಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಪ್ರತಿ ಕಚೇರಿಯಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ದೂರುಗಳ ಬಗ್ಗೆ ಕೂಡಲೇ ಕ್ರಮ ತೆಗೆದುಕೊಂಡು ಕ್ರಮದ ಬಗ್ಗೆ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ತಿಳಿಸಲಾಗಿದೆ. ಅಧೀನ ಕಚೇರಿಗಳ ತಪಾಸಣೆ ಸಮಯದಲ್ಲಿ ದೂರು ರಿಜಿಸ್ಟರ್ ಪರಿಶೀಲಾಗಿ ಮಾತ್ರ ನೋಂದಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಇನ್ನು ಮುಂದೆ ದೂರವಾಣಿಯ ಮೂಲಕ ನೀಡುವಂತ ದೂರುಗಳ ಬಗ್ಗೆ ದೂರುದಾರರಿಗೆ ಸೂಕ್ತ ಹಿಂಬರವನ್ನು ನೀಡಿ ಇವರುಗಳ ರಿಜಿಸ್ಟಾರ್ ನೋಂದಾಯಿಸಲು. So that is, you have to take action, you have to inform the concerned complainant, and this is the detailed procedure in respect of complaint. So when I received the complaint from this particular news agency, my lord, then my lord, I issued notices to the concerned officers under me, that is assistant controller one Srimati Seema Maggie, A2 page number 64. Saying that she along with one Shivkumar Melody, an agent, they are responsible for these things. Therefore, I have received a complaint. Please give their explanation. That's what I have said. Page number 62, 64. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆಯ ಎಲ್ಲಾ ಸಹಾಯಕ ನಿರ್ವಹಣೆ ಎಂದರೆ ಎಚ್ ಪಿಲ್ಲಯ್ಯ, ಸಂಪಾದಕರು, ಉಗ್ರ ನ್ಯೂಸ್ ಪತ್ರಿಕೆ ಸಂಸ್ಥು ಈ ಕಚೇರಿಗೆ ದೂರನ್ನು ನೀಡಿ ಸದರಿ ದೂರಿನಲ್ಲಿ ರಾಜಧಾನಿ ಬೆಂಗಳೂರಿನ ಬಹುತೇಕ ಪಂಪ್ಗಳಲ್ಲಿ ಲೀಟರ್ 5 ml ಕದಿಯುವ ದಂಧೆಗೆ ಅಳತೆ ಮತ್ತು ಸರ್ಕಾರ ಅವಕಾಶ ಕೊಟ್ಟಿದ್ದಾರೆ. ಬೆಂಗಳೂರಿನ ಪೆಟ್ರೋಲ್ ಬಂಕ್ಗಳಲ್ಲಿ ಸರಾಸರಿ 5 ml ವ್ಯತ್ಯಯ ಬಂದರೆ ಯಾವುದೇ ಬಂಕ್ ವಿರುದ್ಧ ಕೇಸನ್ನು ದಾಖಲಿಸಬಾರದು ಎಂಬ ಅಲಿಖಿತ ನಿಯಮವನ್ನು ಅಳತೆ ಮತ್ತು ತೂಕದ ಇಲಾಖೆ ಅಧಿಕಾರಿಗಳು ಪಾಲಿಸುತ್ತಾರೆ. ದಿನಕ್ಕೆ 20,000 ಲೀಟರ್ ವಹಿವಾಟು ನಡೆಸುವ ಬಂಕ್ಗಳ ಪೆಟ್ರೋಲ್ 5 ml ಹೊಡೆದರೂ ಸಾಕು, ಸಂಜೆಯ ವೇಳೆಗೆ 100 ಲೀಟರ್ ಇಂಧನ ಉಳಿಯುತ್ತದೆ. ಇವತ್ತಿನ ಬೆಲೆಯಲ್ಲಿ 10,000 ರು ದಿನಕ್ಕೂ ಬಂದಾಗಿದೆ. ಬೆಂಗಳೂರಿನ ಸುಮಾರು 1,000 ಪೆಟ್ರೋಲ್ ಬಂಕ್ಗಳಿದ್ದು ತಿಂಗಳಲ್ಲಿ 10,000 ರೂಪಾಯಿದಲ್ಲಿ 1 ಕೋಟಿ ರು ವಹಿವಾಟು ಹೋಗುತ್ತೆ ಎಂದು ಆರೋಪ ಕೇಳಿ ಬಂದು MIL ಪಕ್ಕದಲ್ಲಿ ಕದಿಯುವ ದಂಧೆ ಅವಕಾಶ ಮಾಡಿತ್ತು. ಅಳತೆ ಮತ್ತು ತೂಕದ ಅಧಿಕಾರಿಗಳ ತಿಂಗಳ ಮಾಮೂಲಿ VCT 10,000 ಕೊಡ್ತಾರೆ ಎಂದು ಮಾತು ಕೇಳಿ CCTV ಮೊಬೈಲ್ ಕಾರಣದಿಂದ ಅಧಿಕಾರಿಗಳು ಇದನ್ನು ನಿರ್ವಹಣೆ ಮಾಡಲು ದಳ್ಳಾಳಿಯನ್ನು ನೇಮಿಸಿಕೊಂಡಿದ್ದಾರೆ. So this was the complaint. What do you say? This is what I have issued a notice to the assistant controller. Similar notices were issued to other officers, my lord. And the Seema Maggie has been kept under suspension because of this allegation. But after having issued notice to them, my lord, I addressed a letter to the controller, annexure A4, page number 69. On 17/9/2021, I addressed a letter to the controller saying that this is the complaint received, and on that I have issued notices to these people, and appropriate action may be taken. On page number 76, my lord, after enumerating all these things, what I have stated is, ಆದ್ರಿಂದ ಈ ಪತ್ರದೊಂದಿಗೆ ಎಚ್ ಪಿಳ್ಳಯ್ಯರವರು ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿರುವ ದೂರಿನ ಪ್ರತಿ CD ಹಾಗೂ ಕಚೇರಿಯಿಂದ ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆಯ 4 ಸಹಾಯಕ ನಿಯಂತ್ರಕರಿಗೆ ನೀಡಲಾದ ಜ್ಞಾಪನ ಪತ್ರ ಪ್ರತಿಯನ್ನು ಅಡಕವಿಟ್ಟು ಮುಂದಿನ ಕ್ರಮವನ್ನ ತಗೊಳ್ಳಿ ಅಂತ ಕಂಟ್ರೋಲರ್ಗೆ ಹೇಳಿದ್ದು. ಪ್ರತಿಯನ್ನು ಕಾಪಿ ಆಫ್ ದಿಸ್ ಹ್ಯಾಸ್ ಬೀನ್ ಅಡ್ರೆಸ್ ಟು ಪಿಲ್ಲಯ್ಯ ಆಲ್ಸೋ, ಬಿಕಾಸ್ ಈ ಕಂಪ್ಲೇಂಟ್ ಐ ಆಮ್ ಸಪೋಸ್ ಟು ಗಿವ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್. ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಡನ್ ದಿಸ್, ಮೈ ಲಾರ್ಡ್, ಐ ಹ್ಯಾವ್ ಮೈಸೆಲ್ಫ್ ಬೀನ್ ಇಶ್ಯೂಡ್ ಎ ನೋಟಿಸ್. ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 77, annexure A5, for having taken action, my lord. ಮಂಜುನಾಥ, ಈ ಕಾನೂನು ಮಾಪನ ಉಪನಿಯಂತ್ರಕರು ಬೆಂಗಳೂರು ಜಿಲ್ಲೆಯಾದ ನೀವು ಶ್ರೀಮತಿ ಕೆ ಸೀಮಾ, ಕಾನೂನು ಮಾಪನ ಸಹಾಯಕ ಹಾಲಿ ಅಮಾನತ್ತು, ಇವರು ಬೂದಿಗೆರೆ ಕ್ರಾಸ್ ಪೆಟ್ರೋಲ್ ಬಂಕ್ ನಲ್ಲಿ ಶಿವಕುಮಾರ್ ದುರಸ್ತಿದಾರರೊಂದಿಗೆ ಭೇಟಿ ನೀಡಿತು ಮತ್ತು ಹಪ್ತಾ ವಸೂಲಿ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಅಧಿಕಾರಿಯನ್ನು ಸರ್ಕಾರವು ಈಗಾಗಲೇ ಅಮಾನತುಗೊಳಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. ಈ ಸಂಬಂಧ ಇಲಾಖಾ ವಿಚಾರಣೆ ಚಾಲ್ತಿ ಇರುತ್ತೆ. ಆದರೂ ಸಹ ನೀವು ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ವರದಿ ಮಾಡಿರುವ ಅಂಶಗಳು ನ್ಯೂಸ್ 1 ಚಾನೆಲ್ ನಲ್ಲಿ ದಿನಾಂಕ 29/21 ಪ್ರಸಾರವಾಗಿರುತ್ತದೆ. The Pillappa whom I gave an endorsement, my lord, he approached the channel and he has given the news. Therefore, news channel has published it. For that, my lord, last para, ನೀವು ಜವಾಬ್ದಾರಿತ ಅಧಿಕಾರಿಯಾಗಿದ್ದು ಮೇಲಧಿಕಾರಿಗಳ ಗಮನಕ್ಕೆ ತರದೆ ನೇರವಾಗಿ ಸುದ್ದಿ ಮಾಧ್ಯಮಕ್ಕೆ ಹೇಳಿಕೆ, I have not given any statement, my lord, that Pillappa whom I have given endorsement having taken the action, he has moved. And then, my lord, on this ground, my lord, when the notice was issued to me, I submitted a reply, annexure A6, page number 78. A detailed reply was published where I have said that whatever action I have taken, I have given a detailed reply, my lord. And this reply, kindly see the notice date, my lord. Annexure A5 is dated 1/10. It was served on me on 4/10, my lord. Even before I could give the reply, 4/10, I have given within 3 days, on 7/10/2021, I have given the reply. But before that, I am kept under suspension, my lord. Kindly see page number 87, annexure A8. 3 days ಅಲ್ಲಿ ಅವರು ರಿಪ್ಲೈ ಕೊಡಿ, 2 ದಿವಸಗಳಿಗೆ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು. 4 ನನಗೆ ಸರ್ವ್ ಆಗಿದ್ದು 4, and 7th I have given, my lord. Before that, already suspension order 87. This is the order I questioned before the tribunal. And what is the misconduct committed by me? Because I have
What is
taken
the
action against
statement
the
made to the
officer.
media? Yes, please wait. What is the statement made to the media? Where is the material? Where is the material? Where is the material? In protocol, like, we understand protocols. Where is the material?
My lord, I have myself obtained a letter from the.
Please wait, Mr. Joyce.
I'm sorry.
You want to argue on behalf of
No,
the
no.
government also? You are welcome. Please do it.
I'm
It will
sorry.
reduce our burden. What secure the records? So what happens? Somebody has received, he has given a complaint, he has acted on the complaint. So what is wrong? What protocol? But he should not admit that he has received a complaint. Where is that material? Where has the tribunal gone into that? What is the statement made by him? What is the material put against him? Yes, what is the material put
My
against
lord,
him?
annexure A9, page number 117, because they made the allegation that I have go to the press, then I got the information from the press only by issuing a notice. Annexure A9, my lord. A9 is the notice issued by me to the press that as to, I have not given any statement. Page number 117. My client has kept on suspension by the government and Consumer Affairs Department allegation that he has given a statement to your news channel in respect of allegation made against Seema. Therefore, I request you to kindly provide me information in writing whether my client Manjunath has given any statement to your news channel in respect of allegation made against Srimati Seema. Further, I request to provide the CD in respect of telecast so and so. Therefore, that my lord, reply received is A10. That is the press people, they have said ಕಾನೂನು ಮಾಪನ ಸೋನ್ಸೋ ಅಪ್ಪಾಜಿ ಆದ ನಾನು ನ್ಯೂಸ್ ಫಸ್ಟ್ ಕನ್ನಡ ವಾಹಿನಿಗೆ ವ್ಯವಸ್ಥಾಪಕನಾಗಿ ಕರ್ತವ್ಯ ನಿಷ್ಠೆಯನ್ನೇ 27/10/21 ನಿಮ್ಮ ಕಚೇರಿಯಿಂದ ನಮಗೆ ಪತ್ರ ಬಂದಿದೆ. ಅದರಲ್ಲಿ ನೀವು ಹೇಳಿದಂತೆ ಕಾನೂನು ಮಾಪನ ಶಾಸ್ತ್ರೀಯ ಖಾಲಿ ಡೆಪ್ಯೂಟಿ ಕಂಟ್ರೋಲರ್ ಮಂಜುನಾಥಿ ಅವರು ಅಮಾನತಾಗಿರೋ ಬಗ್ಗೆ ತಿಳಿಸಿರುತ್ತೀರಿ. ಅದಕ್ಕೆ ಕಾರಣ ನ್ಯೂಸ್ ಫಸ್ಟ್ ಕನ್ನಡಕ್ಕೆ ಆಗಿರುವ ಈಗಾಗಲೇ ಇಲಾಖೆಯಲ್ಲಿ ಭ್ರಷ್ಟಾಚಾರ ಆರೋಪದಲ್ಲಿ ಅಮಾನತಾಗಿರುವ ಶ್ರೀ ಸೀಮಾ ಕೆ ಮ್ಯಾಗಿರವರು ಬಗ್ಗೆ ನೀಡಿದ ಹೇಳಿಕೆ ಕಾರಣ ಎಂದು ತಿಳಿಸಿರ್ತೀರಿ. ಈ ಬಗ್ಗೆ ನಮ್ಮ ವರದಿಗಾರರನ್ನು ಕೇಳಿದಾಗ ಅವರು ನಮಗೆ ಸೀಮಾ ಕಿ ಮ್ಯಾಗಿ ಅವರ ಬಗ್ಗೆ ಡೆಪ್ಯೂಟಿ ಕಂಟ್ರೋಲರ್ ಮಂಜುನಾಥ್ ಅವರು ಯಾವುದೇ
The applicant was not supposed to make such information to the news channel, and he was not supposed to. Then ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಮತ್ತೆ ಇವರು Yes, get the material by afternoon. By today afternoon. Nothing in the petition. Why? What is there in this case? They have placed material before the tribunal where the communication issued by the whatever channel that he has not issued any statement, he has not given any material, that is not controverted. Tribunal does not go into it. It does not even call upon you to place material. And it says we will not interfere with the suspension order. only because he's doing his duty, performing his duty. Or make a statement, whoever performs duty will be punished, we will dismiss the petition. Then ask your DPI secretary to come and make a statement, file an affidavit. We will take action against whoever performs this duty. This is not the first case. In respect of that sub-inspector also, you have done the same thing. We have taken action because he abused a higher officer who was indulging in criminal activities. What is happening? Just get the material by Atman. Who should be summoned? Ask them to bring it. A second respondent to place before the court the alleged statement material demonstrating any statement made by the petitioner before this court.
2:30, madam.
2:30. Yes. Their office is right across. Barakil, no Barakil.
I'm for the petitioner, my lord.
Yes.
Right, petitioner is working as assistant engineer, my lord. He belongs to Public Works Department. He was on deputation to BBMP Corporation, my lord. On the allegation that there is violation in building bylaws, my lord, a penalty of withholding 2 improvements with cumulative effect was affected. My lord, that was under challenge, my lord, on 3 legal grounds, my lord, before the tribunal. Kindly see page 48, my lord, the 3 legal grounds which I had urged. Lord, the first ground is that the recommendations made by the Lokayukta has not been furnished in terms of Rule 12A of the CCA rules, my lord, along with the second showcase notice. Second ground was, my lord, the entire...
Completed, take notice. Yes, and HGP accepts notice on behalf of respondents 1 and 2. 2 of us were the third respondent, BBMP. The Metro. The Council M.H. Subramania accepts notice on behalf of the third respondent.
Lord, sought for an interim stay, my lord. Let the
Next week. Next week. Next week.
Please.
Okay. Why did you file them? Don't have instruction. Why did you file? It is. I think we are being lenient with you. We'll dismiss it. You have no instruction. We'll dismiss it. You have no instructions. That is just a statement. We are recording it and dismissing it. Yes. What is it?
Third party was not involved in the case. It's a complaint to the authority. But complaining that there were 2 orders prepared by the assistant commissioner. One dismissing the appeal, one allowing the appeal. And he allows the complaint, he produces it. Xerox copy of the complaint. The lawyer may kindly come to Xerox copy of the page 77 for page 77. Dated 21/7/2014. Next to be an activist and fight complaint. But we go to the last. That page, the last one.
Yes. Is that record that is Paris? What happened? Where is the two orders?
I saw the Honorable Court order after 2 days. We lettered it 28/9/2014. So they have received the record. But the 28 but the 8/12/2021. The other
Yes. Yes. Hmm? Where is the letter? Where is the letter 28/9?
Personal report, there are no 2 orders. The complainant gives a Xerox copy. That letter does not bear out.
There's a stay.
But,
Report is there.
not to precipitate.
Heard. Better request concentration. You will say the proceedings insofar as the petitioner is concerned. Huh? Yes. Pursuant in compliance with the heard the learned senior counsel, K. N. Panindra, along with the learned counsel of the petitioner and the learned HCG. We have perused the affidavit dated 6/12/2021, filed in compliance with the order dated 8/12/2021. The records were summoned and the records have also been perused. As deposed in the affidavit, we find that there is only one certified copy. There is only one copy of the order, and the alleged second copy as deposed by the as deposed appears to be in the Xerox copy only. Appears to have been forwarded by the Revenue Department. Neither the source of the alleged second order nor any material found in the records incriminating incriminating the petitioner. But it is also not in dispute that an inquiry initiated against the states of the respondent state has also not found favor in the inquiry authority. One Monish Mujil has also submitted a report negating the alleged complaint. In that previous matter, there should be a stay of for the proceedings insofar as the petitioner is concerned. The order shall not come in the way of the respondents continuing with the inquiry in respect of the other officers. Admit. Move an application, let them file their objections. Pleadings are not complete. Yes. The respondent to complete their pleadings in 4 weeks before hearing thereafter. Yes. Records may be returned to the learned HCGP after obtaining appropriate acknowledgement. Next.
Is it number 10, my lord?
Yes.
My lord, I represent petitioner. My lord, here, my lord, the first respondent illegally distributed the land, sand. Against that, my lord, a complaint was registered. After inquiry, my lord, second 12-3 report has been submitted to the government. The government passed an order under Rule 14A. My lord, that has been questioned before the KAT. My lord, KAT has set aside that order with liberty to the government to pass fresh order after second 12-3 inquiry. Kindly see the order, my lord, page 42. Impugn order 42.
Puttegowda,
My lord,
where is your locus standi? How do you maintain this writ petition?
my lord, there was an inquiry. It has been reported to the.
What is the 12-4? 12.4 ಕೆಳಗಡೆ what is the alternative ಅನ್ನೋದು ಇದೆಯಲ್ಲ?
ಅಲ್ಲ 14A ಕೆಳಗಡೆ they have issued an order that has been questioned, my lord.
So they have to come up, not you. You are
Because
only an
they have
enabler.
not, my lord, even Lokayukta is also.
ಯಾವ್ದಿದೆಯಮ್ಮ ಅವ್ರದ್ದು ಇದು ಲೋಕ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಬಗ್ಗೆ ಥರ್ಸ್ಡೇಗೆ ಹಾಕಿ. List this on 24 along with the what remains here? TGP subject as it relates to counseling of the year 2020. Submission is placed on record. Petition is dismissed as having been rendered incomplete. Yes, next.
Is it posted to 24/4/2, my lord?
24 to 24.
Public.
What is it?
Additional list was published by Lord and name was not found. He has given representation by Lord and there was endorsement was one appointed by the application before the AAD. Before the AAD. AAD after the span of 17 years, my Lord, is allowed the application, my Lord, and allowed the application and controlled the delay of 1,295 days, my Lord.
It is submitted that the first respondent approached the tribunal by way of an application in respect of concluded in 1998.
Yes. Asking the seniority as juniors have been selected, my Lord.
And, it approached the tribunal after 17 long years to do the seniority list of primary school teachers. NFSC, the application appears to be initiated by delay and latches. Hence, there shall be an interim stay of the operation of the order dated 16/6/2021, passed in application number 4369 and 4541 of 2009. Notice. Yes.
Officials, and they are daily wages employees, my Lord, they are not government employees, my Lord. But he is only skilled, my Lord, and governed by the ID Act, my Lord. But the tribunal considered them as civil servant, my Lord, and has allowed the application, my Lord, that can be the order, my Lord. The order is at 33 days, 33. The applications are disposal of in terms of the decision of this tribunal dated 3/2/2022. Under the connected cases, the respondents are directed to extend the benefit of family pension Arrears of pension and pensionary benefits to the applicant by virtue of Rule 2A of KCR in view of the decision of this Honorable 6723, 6727 and the connected cases and annexion A2 and D4 dated 11/6/2012 and annexion A4 with all consequential as per the government order. This exercise shall be done within
Yes, whether this order has become final, 2009 order,
the facts are very different, my lord.
what is different of,
Yes, my lord. I will submit to the court, my lord.
yes,
My lord, first respondent has not produced to show that the service are regularized. And also the second
service are regularized or not is a matter of record with the department. But they have not produced to show me what kind of argument. Which department are they from?
they are from
Silk board. Silk board, Karnataka, state silk board. ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ರೀ, ಯಾವ ಬೋರ್ಡ್? ಕಮಿಷನರ್ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಸೆರಿಕಲ್ಚರ್. Sericulture department. Your department does, you don't know what your department is doing. You don't know what records your department is having. Why do you want to throw the burden on the PD applicant? When all the records are in your possession. Drag on the issue, send it back, remand, spend another few years. What is this? Have you questioned this 2009 order? That order has become final. Tribunal says the petitioners are also similarly placed as those petitioners. Then what is there? Go to that relevant paragraph. See para 6, yes. Council for we. Issue notice. Issue emergent notice. It is made clear that issuance of notice shall not be a ground for the petitioners for the petitioner to deny the respondent benefits that accrue under the order include. Any benefits extended will be subject to the final orders that may be passed in the writ petition. Yes. order. ಎಲ್ಲ ರಿಟೈರ್ ಆಗಿ ಹೋಗಿರ್ತಾರೆ ಈಗ. What has happened? What is wrong? What is wrong with the order? ಯಾರು ಬಂದ್ರು ಅದನ್ನು 25 ಇದು ಬರೋದು ಏನೋ. ಎಸ್ allegations. Allegations were made. You're going to find an affidavit.
Has come on record was the petitioner was only a clear engineer. Because the entire processing of the bill, because it has to be cleared by the executive engineer on the recommendation of the assistant engineer.
So JE prepares the running bill account, he verifies it. Running,
He had conducted as spot inspection. One of the on the spot inspection, it was found that certain works were not carried out by him. He was asked to
certified. Yet he certified it. It cannot be released without his certification.
It has to be done by the assistant executive, not the secretary.
Said executive engineer is not required to leave his chambers. Executive engineer is not required to even get up from his chair. That is the unwritten rule that is followed. And if your client JE is finding it difficult, what do you?
He was not the authority to either clear or to recommend the executive.
He is the one who certifies. He is the one who certifies.
Certification because
The officers in the higher echelons always ensure buffer zone and scapegoat.
certification was done by the AWE.
Yes.
Same allegation. There must be a conduit to the I acknowledge that the burden of
Trap case.
But the shadow witness says, I have not seen the petitioner either demanding the money or accepting the money.
Let's take notice. The HCGP accepts notice on behalf of respondents 1 and 3. Who's 4? You notice to the 4th respondent. Where is Mr. Vintage Arbati? Who appears for Lokaita? Ashwin Hardy accepts notice on behalf of the second respondent. To furnish copies of the petition to the learned HCGP and the learned counsel for the second respondent. Yes, list after the completion of service on the 4th respondent. Yes. Contrary to settled law. Could you be working after there is an order of dismissal? That itself shows at what level they have. It's a problem with this department. They have become immune. There is the question of even giving me permission to enter the office premises. Yes.
And you know, people are also accept there is some case for the applicant. But people take that I have not made objection to the answer. So the applicants have ready to also get ready to
So what is the interim relief situation?
and your lordship on the base of it, you can also accept. I have been able to demonstrate the key answer or down from the textbook. We don't require any other to if you were 25 or they have able to demonstrate the key answer.
We'll ask the department to keep on post vacant. ಏನಾಗಿದೆ ಈಗ KPSC you appears for KPSC
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬಹುದಾ
ಕೊಟ್ಟಿದ್ದಾರಮ್ಮ ಲಿಸ್ಟ್ ಇದೆಯಾ
ಸಿಂಚನ ಇದ್ದಾರೆ ಅಶ್ವಿನ್ ಹಾಲಡಿ ವೆಂಕಟೇಶ್ವರ ಪಟ್ಟಿ
ಅಶಕರಿ ಅಪಿಯರ್ ಫಾರ್ KPSC ಬೇಡ ಹಾಗಾದ್ರೆ ನೀವು ಪ್ರೈವೇಟ್ ನೋಡಿ ಯಾರಿಗೆ you are a flower that bees are flocking to. Why do you want to get caged? Yes. If you notice, Yarma? Yes. Huh? It's on the panel. Where is he? Where is he? No. The Land Council, Mohammed Sami is directed to take notice on behalf of the respondent. This is next week. The petitioner shall submit the petition to the Learned Council to the respondent. Say, Martha, link Martha. Monday, 28th, 28th. Yes. Next.
The question is selection of construction of the household for the fishermen. Government brought up this scheme. Problem of selecting the candidate, and they selected candidate. They were all paid money, and money was paid to their account. Somebody got a complaint. Market to not to buy it. Guarantee superate of police to investigate. Investigation of the report, which I agree to the law. That investigation is do so properly.
any further in the state, so far the reputation and really on the 12 foot kilometer. So they had
ಯಾವ್ದದು?
Sanjeev Kumar versus State of Karnataka, where you were also rated at these points. You were also rated at 3 points. That point is whether the application before the business commission was also considered as the fact of the other case is exactly what it was.
ಅದು ಇಲ್ಲಲ್ಲಪ್ಪ.
Very strong, very strong.
What is this? The petition it is submitted. Delaney counsel for the petition inauguration. Delaney CGP. Delaney counsel for the petition submit that that a scheme was certain a scheme was created by the state whereby certain assistance monetary assistance was given to fisher folk to build build houses that that one B Lingaraju lodged a complaint on 28/7/2014, alleging that the petitioner had misappropriated funds. On the basis of the said complaint, the Lokayukta directed an inquiry by the deputy superintendent of police and the deputy and the DYSP submitted a report negating the allegations. But despite that, despite the said report, the Lokayukta wrote the state government requesting that the inquiry be entrusted to them under section 14A, that the state government, without application of fine and without reference to the report of the deputy own report and the records as blindly handed over the inquiry. The fact that the investigative wing of the Lokayukta has given a report exonerating the petitioner is not controverted. That view of the matter, there shall be an interim order as prayed. This the exit notice on behalf of one and two. Why do you want four? Council, the Ashwin already is directed to take notice on behalf of respondents 3 and 4. Copies of the petition to the learned council by respondent 3 and 4. Yes. This is after 2 weeks. Readings by then. Readings to be completed by then. Yes. Let's get ready. Take the copies today and serve it today. Take. Yes. No.
You have to take action against them. On the basis of said information, so the complaint will be registered as per the Lord's division A9 and the Lord's 10. Divided by the Lord's page number 69 and 70. On 28/8/2021, the request the Lord's to page 61. Page 61.
Issue ಮಾಡೋದಕ್ಕಿಂತ ಮುಂಚೆ showcase notice. The showcase notice is based on. To correct that the memo was served after the showcase notice. Learn counsel for the petitioner. The short point that is urged is that the short point that is urged is that the order that the proceedings showcase notice is predetermined. That the said fact is demonstrated by the very action of the respondent, whereby the showcase notice has preceded the memo. But the basis of the showcase notice is alleged to be the allegations contained in the memo. In our prima facie opinion, the petitioner the petitioner has made out a. Are you able to follow, madam? Huh? Sorry, you should tell me. Please come forward. I'm not able to hear you. Yes.
Short point that Alex is not constitutional. So the proceedings show cause notice is predetermined. That fact is demonstrated by
the very action of the which respondent? Second respondent, the fifth respondent, whereby the show cause notice, dated 3/9/2021 has preceded the memo 28/8/2021, and that the basis for the show cause notice is the allegations in the memo. In a prima facie opinion, there appears to be some substance in the contention canvassed by the petitioner. In that way of the matter, there should be an interim order as prayed for. When HCGP accepts notice on behalf of respondents 1 to 5. Pleading objections, if any, in 2 weeks. Yes. Right. Huh? ಮಾಡಿ ಕಂಟೆಂಪ್ಟಿಗೆ ಕಳ್ಸೋಣ. ಇವೆಲ್ಲ ಕತೆ ಆಯ್ತಲ್ಲ, ಅಷ್ಟೇ ಕೊಟ್ಮೇಲೆ ಮತ್ತೆ ಆರ್ಡರ್ ಕೊಟ್ಟಿಲ್ಲ, ಇವೆಲ್ಲ ಫಾರೆಸ್ಟ್ ಆಫೀಸರ್ಸ್ ಅವೆಲ್ಲ ಮಾಡ್ಲಿ ಯಾರು. ಈ ಪಕ್ಕದಲ್ಲೇ ಬಹಳ ದೂರ ಇಲ್ಲ. You just push it across. The other will take care. You will ensure proper treatment. Yes, yes, yes. Your next case.
Yes, I'm appearing for petition respondent number 1, my lord.
But I appear for the state in this matter. Appear for the government in this matter, once the lordship.
So we will hear it next week. Period will be over. Yes. So term is over. Petition allowed. What do you say, Advocate?
Let's. I'm told it is being posted within the city of Mysore only. I don't think any prejudice is caused unless it is very particular about this post and it comes to an end anyway by May. That's. I think they must be graceful enough, Lord, they must accept it and go ahead. He's being posted in Mysore only. Well, Chescom, he has been posted to Chescom. I'm talking of 19.1. I'm appearing only in 19.1.
19.
19, only 19.1.
Where 19 we are a deputy journaling Shirastadar at the election Shirastadar. Shirastadar. Cinematic effect. What is this? Who appears for the respondent? Serial number 19.
I am appearing for respondent number 1, my lord.
Yes.
This is premature. 1 month is there. 3 months.
Your period ends on 6th of March.
Yes, my lord. 8 March 2000.
You get yourself relieved on 6th.
So it is not a general transfer, my lord.
Period is over. You don't have any lien.
Marks.
What do you say?
It is not a general transfer, it is premature transfer. So
Correct. Even premature transfer, your period ends with 7-3.
yes, my lord.
Ah.
That is
For 4 years.
difficult. Yes, already completed 4 year for on 8/3/6/3/2022.
By 3 you will complete.
Yes, yes, my lord.
Very close to the government. What do you say? What do you say?
My lords, I appear in this matter, my lords, where similar matters connected with this, my lords, been posted on 2nd of March, my lords. There is an instruction by this honorable.
Complete this. Please tell me what is this? Complete this. Yes, Nisha heard the land counsel for the petitioner and the learned HCGP. The respondent is the applicant, and the first respondent is the applicant. Petitioner the respondent before the respondent number
1.
Respondent number 3. The respondent number 3 before the tribunal. The parties are referred to by the nomenclature before the tribunal. Case of the applicant was that Deputy Tahsildar in 2015, 2015, and that thereafter he was promoted as a revenue auditor on 14/12/2016 and posted in the office of the Regional Commissioner Bangalore. That the post of the revenue auditor is equivalent to the post of a deputy tahsildar. That on 6/3/2018, the applicant was transferred from Yeshwantpur Hubli, Bangalore North Taluk, and posted as journaling Sirastadar in the office of the Deputy Commissioner Bangalore. The applicant reported to duty, and since the date of him reporting to duty, he has continued to occupy the post. That on 20/12/2021, the official respondents passed the impugned order transferring the applicant from the post of journaling Chirastadar, office of the Deputy Commissioner Bangalore, posted him as the election Chirastadar, Nelmangala Taluk Office, Bangalore Rural District. The said transfer order is admittedly a few months shy of the minimum period stipulated under the rules. That is, the petitioner effectively had another 3 months out of the 4 years stipulated for the petitioner applicant, for the applicant to complete his tenure, minimum assured tenure under the guidelines. Standard guidelines. The applicant agreed as approached the tribunal on short ground that the transfer is a premature transfer, and that in view of the guidelines, 2013 guidelines, the order being premature is and one being without the concurrence of the chief minister is required to be set aside. The tribunal, accepting the case of the applicant, has been pleased to allow the same. Today, the learned HCGP and the learned counsel for the petitioner submit that in view of the undisputed fact that the period of the that the tenure of the applicant comes to end on 5/3/2022. It is submitted that the order may be made effective, that the transfer order may be read down and be made effective from 7/3/2022. The learned counsel for the applicant would fairly admit that he completes his tenure on 5/3/2022. In that view of the matter, and in view of the fact that that the proposed place of transfer being within a communicable distance and within a communicable distance and there being no serious prejudice being caused to the petitioner in terms of dislocation of family or dislocation of family or himself, and the proposed transfer being just a few months, just a couple of months shy of the period contemplated under the guidelines. We deem it appropriate to direct that the order of transfer, the order impugned, Annexure A4, order impugned. The order of transfer be made effective from 7/3/2022. In that view of the matter, the order of the tribunal is set aside. The writ petition is partly allowed. It is made clear that the order shall become the order of transfer impugned shall become effective with effect from 7/3/2022. Petition stands ordered accordingly. Yes.
Making point.
Who?
ಅದೇನು ಮಾತ್ರನೇ
ಇದು premature transfer ಏನ? Who is this Lakshmikant Reddy? Who is this Natesh? Who is your competitor working as Muda? Huh?
ಇಲ್ಲ
He's posted there. Yeah. Just come. Mysore, Chamundeshwari. What is this? This street to that street. What is political about this? You say if allegations are stated, you will say it is a punishment transfer. You cannot transfer me without inquiry. Huh? See, both within the same city. Then what is your vested interest? Why do you want? Correct. There should be some prejudice. The same city, same street, and no. See, the law, the apex court has also upheld the principle of communicable distance, doctrine of prejudice. See, we'll have to balance. See, law is, you cannot apply law in a straitjacket, man. Law has to be looked into in the facts and circumstances. Yes, certainly if you know posting is given, this court would be the last one to interpret. The posting is given of what is see, whatever reason we cannot keep going into every reason unless there is glaring. If there is a glaring malafide, yes. Glaring malafide. What is the malafide? What is the malafide that you have alleged? Can't say that you can't exclude them totally. If they are dissatisfied, who has to answer the people? You are not answerable to the public. But see, Mr. Purnana, I think your association with elected representatives is quite well known. You know very well that the ultimate it lies in the lap of the elected representatives. If the anger is vented by the public, it is vented at these elected representatives. Anybody else arguing this point, I would have at least spared some moment. Hey, I said, no, your previous avatar should not fade away from your mind. See, what is the prejudice that is caused? That is all. That may not be correct in every, unless you can say there are some malafides or something, it may not be correct.
Yes, sir. As per guidelines.
We say, you can't say it so. Oh, how much more time you have? Same order. Same order. Or you want to? Even if they argue, you are not entitled to you can stay there beyond your period. What is there? We will read down the order. Read down the order. That is, see, basically, there are enough number of petitions where I've taken a view. There is no actual prejudice to the officer, and there is, and if it is within communicable distance. My view on that point is well said. I do not interfere. These guidelines, I am not in favor of implementing the guidelines blindly. Guidelines, yes, they are there to protect the officers against any whimsical treatment. There can be no doubt about it. But mere academic say, no, I have been transferred from the A street to B street, or from building number 1 to building number 2. It is my prestige, it is my ego. But in the end, what else is this? Unless it is, see, unless some malafide is attached, whether it be appropriate to look into every decision, executive decision of the government. Huh? Wait, what about today? Huh? Huh. See, even otherwise, just the previous matter, we have passed an order. If he is going to insist on that, we will hold it. We'll just read down the order, we'll make it effective. Huh? Password. Get the instant. See, there can be no two opinions about the fact that officers must be protected. There are enough number of transfers where we have interfered with. Similarly, also, there is no prejudice, there is no inconvenience to the officer coming. And in fact, the other day I have asked the AG, who was Subramania, or Mr. Jan. I asked him to suggested that they take viewed seriously, take a relook of these policies. Well, yeah, correct. There is some. See, somewhere the transfer could be punitive by itself. No, say from Kolar to Yadgir. If you are shunted from Kolar to Yadgir or from Kolar to Karwar, certainly yes. See, now what will happen? This person will be sending his children to the same school. Probably he'll be visiting the same saloon. He'll be buying his vegetable and fruits from the same vendor. What is the prejudice to him? This is want me to tell what we can tell. Somehow the officers, were fighting a transfer within the same city or within, it's something inexplicable. I don't find any rhyme or reason. Stretching, probably we have stretched it a little too far. Yes, at that point of time when housing was a problem, education was a problem, higher education was a problem. Yes, it can't be. Correct, we see. Right. Substantial period is completed. Another 2 months, 3 months fighting. It's a different impression. It gives a different impression to the court that the officer is having some vested interest, he wants to hold on to that seat. But why do you all do it when there are still 2 months, 3 months? Advocate General.
Yes.
1 or 2 months you could have just said with effect from at least adopt that measure henceforth.
I only request.
Advocate General.
Yes.
The court has in fact suggested the other day. Yes, I think in this matter only. Mr. Jan Chinnappa was appearing in some other matter. We asked him. No, I think Mr. Subramania. I think so. Yes, Mr. Subramania.
Yes.
And we asked him to have a relook at this. See, somewhere where the substantial period is complete, or something where it is make an exception within the city, within the same city, they should not be coming to courts. These are matters, yes. Correct. They must get correct. See, yeah, 18 ತಿಂಗಳಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಕೆಲಸ ಇನ್ನು 6 ತಿಂಗಳಲ್ಲಿ ಮಾಡ್ಬಿಡ್ತಾರ. ಅವೆಲ್ಲ ಆ ಕಾಲ ಇತ್ತು. ಅಧಿಕಾರಿಗಳು ಮಾಡ್ತಾ ಇದ್ರು, ಮಾಡೋ ಅಧಿಕಾರಿಗಳು ಇದ್ರು. ಅಷ್ಟೇ.
But only request is not different.
The 1 year to 12 months, 24 months, even if for an officer who is competent and is working, even 6 months is enough. He will give you results. If you have an incompetent hand and have him there for 5 years, he will only be warming the bench. That's all. Nothing more. He won't do anything more. Tenure doesn't count. Competent and works with it. Yes, tomorrow. Next.
Lords are passing it on.
Tomorrow. Yes.
Lordships are passing it on. I couldn't hear, Lords.
Tomorrow.
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 Yes.
So item number 20, I appear for the petitioner. It is a case of premature transfer. If my lords would kindly turn to page 41. The applicant reported for duties at Bagepalli on 18/2/2021. Within 10 months thereafter, my lords, he has been now transferred by annexure A6, page 47. To bring in there respondent number 2 prematurely. In fact, my lords, the second respondent had been transferred from Chikbalapur to Madhugiri only on 9/4/2021. That order is there at page 44. To bring him back to Chikbalapur district within 8 months, I have been transferred by annexure A6, page 47, without giving me a posting, leaving me in marooning me in thin air. And I approached the tribunal, my lords. Tribunal holds, since I am only a Rule 32 Tahsildar, I have no tenure, and my application is dismissed, and a direction is given to post me as Siristedar. And Rule 32, my lords, there is no such distinction in law. On an earlier occasion, by an order at page 49, the tribunal had rejected the contention based on Rule 32. Tribunal writes that independent charge is only an in-charge arrangement on the Tardal Baritar.
In this matter, my lords, With leave of this court, my lords.
And is totally contrary to policy dated 24/11/2021, my lords, where they said no chain transfer and no primitive transfer. That notification of the state government is at page 45. On the COVID policy ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಆ COVID policy ಇಲ್ಲಿ only vacant post ಹಾಕಬೇಕು. Not creating, not vacating the post.
May I submit, my lords? With leave of this court. My lords, now the
Yes.
post has been shown to petitioner, my lords. Order is with my colleague, my lords.
My lords, that is not a concession, my lords. I have not come here with a begging bowl. Let them answer their own policy page 45.
Their contention is without posting, my lords. Now the subsequent development is that, my lords, posting has been.
See, madam, what was the date he was posted there? 18 to 21. He is assured of a minimum tenure of
2 years. Group B.
December, in 10 months he is shifted. But a substantial period is completed, we can understand. Now, the previous two matters, a substantial period had been completed. What do you say? I think that hope it is not my judgment. Yeah, all that is fine. See, he was in a post. Okay, somebody was transferred and he was put there. What is his mistake? Why, where should he go? Understand that if vacancy is created, he sent there. In fact, I myself have taken a view similar to this, where we have said that they should not keep an officer under Rule 32 for more than 6 months. We have given all those observations.
ಅಲ್ಲ ಇಲ್ಲಿ ರೂಲ್ 30 ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ತಹಸೀಲ್ದಾರ್ಸ್ 6 ವರ್ಷದಿಂದ ಇದ್ದಾರೆ ಸೀನಿಯಾರಿಟಿ ಲಿಸ್ಟ್ ಫೈನಲೈಸ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ.
Exactly. There was such a case, but that was even worse, where official he was not qualified. Then he was continued with the post.
Their my lords have taken away. He is not qualified to hold the post anta. That is reported also.
I think sitting singly also have taken a view.
Yes.
Apart from the sub-registrar case in Kalburgi. Group D peon is occupying has been running the office for years together. Years together, if I'm right.
10 years.
He was initially appointed as a Group D. And then he manipulates and he is so resourceful that he is able to hold off any appointments there, stave off appointments. And he continued as his luck ran out with us.
He must have not only been registering sale deeds, he must have been executing sale deeds.
After our judgment, it appears that he has again manipulated and come back there.
ಈಗ ಯಾರ ಮೇಲೆ ಕಂಟೆಂಪ್ಟ್ ಇನ್ಶಿಯೇಟ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಗೊತ್ತಿಲ್ಲ.
So this is a case where the bar should take it up, place it before the contempt bench. In spite of our specific direction, yes. Yes, Mr. Rajgopal.
Yes, my lords.
How that posting is given.
My lords, that is no consolation, my lords, because
Not a consolation. We don't say it is consolation. Now that a regular appointment is made, can it be?
No regular appointment that
Can
not,
be
my lords, I can understand, my lords. If a promotion is made and I still remain a surplus rule 32, they can send me, they can revert me. Here nobody is promoted. Kindly see the order.
The person who is appointed is a grade 1 Tahsildar. That's what they say.
No, my lords, no. The grade 1, grade 2, and this is all. I don't want to use a bad word.
Artificial designation.
Artificial designation. They have not categorized the persons as grade 1, grade 2. If my lords would kindly turn to page 57. Tribunal has in an earlier event taken a view that there is no encadrement of posts as grade 1, grade 2. And even the second respondent, though he is described as grade 2, grade 1, he is only a grade 2 also. That he admits at page 61. It is wrong to say that second respondent is grade 1. Kindly see his own reply at para 6, page 67, 61. He pleads that he is only a grade 2 Tahsildar. Page 61, para 6 of his reply statement. This respondent number 2 submits that he is working as regular grade 2 Tahsildar with effect from 25/7/2016, but the applicant is a lower cadre officer. He is in the cadre of deputy Tahsildar, working under Rule 32. Only difference between me and him is he is promoted under Rule 42. I am placed in independent charge under Rule 32.
The difference is substantial. If he is promoted and is.
My lords, about the non-categorization of posts as grade 2 and grade 1, page 57, para 8 of the earlier judgment. The tribunal has categorically held, insofar as the cadre of Tahsildars, there is no encadrement of posts as grade 1, grade 2. Adu sunna on the stagnation movement tara promotion kodtare. But all posts are either grade 2 or grade 1 ಅಂತ ಹೇಳಿದ್ರೆ ಯಾವುದು ಡಿಸಿಗ್ನೇಟ್ ಮಾಡಿಲ್ಲ ಇದುವರೆಗೆ. The only difference between me and the second respondent is
How will the guideline and how will the guideline apply to Rule 32 posting?
Rule 32, my lords, the view taken by this honorable court right from 1960s is that while making a Rule 32 arrangement, a regular promotion process including DPC will have to be held. After DPC finding me fit for promotion, I am placed in Rule 32 under 2 circumstances. One circumstance where there is no promotional post. Another circumstance is where there is a dispute regarding seniority.
Madam, are you ready?
Yes, my lords. Yes, my lords.
Under either circumstance, my lords, I am entitled for regular promotion from the date of Rule 32 arrangement under Rule 3 of the PPP rules, on finalization of seniority.
You are sent to BBMP.
Where was the need to send me out of Bhagyapalli? Kindly see their
Very
policy,
lucrative.
page 45. COVID
Bhagyapalli is more
special
lucrative than BBMP.
not sir, lucrative personnel. My lord, he is in a remote place, Bhagyapalli. He is happy there. Let the second respondent have the profit of lucrative office. I don't want that. Kindly see the policy at page 45, which they say is a COVID special policy. But cases this policy goes on. This policy is valid till the next general transfers on shelter. Page 45, COVID special policy.
Yes, my lords.
What do you want to get ready? We'll dispose it of.
Yes, my lords.
We'll dispose it of next week, Monday. Huh?
My lord, sir,
No
may I
further
make this, my lords?
Yes.
May I request one? Till then, my lords may stay it because kindly have a look at page 45 policy.
Where are you now?
I am nowhere. That is why I said I am marooned in thin air.
Development, my lords, posting is given.
Yes, then other 1 week, we'll close this. Huh? We are what to do? We are not getting sufficient succor from this side. Otherwise, BBM. Said, see, BBMP transfers, we should not see the portals at all. Generally from this ward to that ward. ಒಂದೊಂದು ದಿವಸಕ್ಕೆ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ, ಆಗೋದಿಲ್ಲ. ಒಂದ್ಸಲ ಮಾಡ್ಬೋದು, 2 ಸಲ ಮಾಡ್ಬೋದು. ಎಲ್ಲರೂ ಮಾಡಕ್ಕಾಗಲ್ಲ. No, then you did not go to the front. You already spoke to the you not go to the front. Where I don't wish to sit there. No, then repeat it. This is totally from
I will say that these patents are no. No guidance.
Yes.
But I have theory of this thing to maintain. He was given a duty was 20.
Bhagat, matter of 1 year, 4 transfer orders.
No, no, not that. He has been given a posting from 22 to 21. He has not obtained it at all. And he is
He has said, like we said in the other case, there is nullifies, if there is such kind of whimsical action, definitely we can't turn a blind eye. Matter of 12 months, 4 transfer, 31-12, 15-4, 22-1. What not? Are you saying these the dates are wrong? Are you saying these dates are wrong?
Then it was rebranded with the commission.
No, see, if this is not mala fide action, what else is? Matter of 12 months, if an officer is going to be shunted 4 times around, that doesn't sound too well for administration.
Not so. But additional has been posted as an assistant director of road planning for 19,320. That is not section A1. Additional report. Not fine. Director R1 page 72. Right. Yes, joint duty not. I'm saying not to be
The BPMP.
My lord, notice has not yet been issued, but copy is served on me, my lord.
Oh, Mr. Bhagwat, this is not, see, you post him, wait, post him on 9th. Then again another order, you give in charge of the post. Right. Which order is required? Then that post is vacant.
But he has been given a posting on 22/12/21.
That has been set aside.
No, it is not.
Yes, by this court, that is what is recorded by the tribunal. Huh? He says that, no, he says the other order giving in charge is recalled. Then what remains in your application? You go report for duty. But you challenge that. Why do you see the matter is seized up by the courts? Government,
Yes, my lord.
why do you take such action without the leave of the court? Matter is pending before the court.
Yes, my lord.
Does it not reflect a malafide action?
My lords, order passed by the BBMP, my lords.
How can BBMP pass an order? Repatriation has to be by the parent department.
Yes, my lord. Repatriation is done by the parent department. So far as another
That is
subsequent.
what you are asking. How can they do it when matter is seized up by the court? Or you should have informed the court, taken the leave of the court and done it.
There is no stay order in this matter.
So we'll give a stay now, we'll complicate everything. What kind of attitude is this?
My lords,
Is it not an act of overreach? But courts are inconsequential to the executive.
my lords, his period, deputation period has completed. Hence, he has been repatriated to the parent department, ma'am.
You could have said so to the court. You could have informed the court. We are repatriating him. Permit us to repatriate him. Matter would have ended.
Yes, ma'am.
They said that order is recalled. 10-12. 10-12 appointing him in charge is recalled. That's what Mr. Bhagwat said. Look into it. Government, you take proper instructions.
Yes,
I
ma'am.
will call it on Friday. If we are not satisfied, we'll summon the secretary. We can't allow this to. There is an earlier order of this High Court to continue him in BBMP, setting aside his repatriation. Again, you come up with the repatriation. If this is not a legal malice, what else is?
I'll get an instruction, my
What
lords.
is the BBMP?
Please, my lord, please.
What is BBMP is a party?
Please, my lord, it is a party.
Huh?
My lord. Please, my lord.
What are you doing here?
Please, my lord. Please, my lord. What has happened was there was
And what is this? Some silent movie or something? You're remaining mum.
what has happened was, my lord, the applicant had done some dereliction of duty, my lord. He had
You
called.
post him on 9. 1 minute. You post him on 9 to one particular post. Then on 10th, you post another person as in charge. What is this?
Sir.
Who has passed this order? 9-12 and 10-12.
Respondent BBMP.
You are, then I think it's better we summon him. Let him come and explain. R2 is not served.
No, please, my lord. R2 copy is served, my lord. Notice is not issued, my lord.
Children Council Cincinnati is directed to take notice on behalf of who appears? Anybody here who appears for BBMP?
I'm here, my lord. I'm here, my lord.
What's your name?
Gautam, my lord. BS Gautam, my lord.
Takes notice on behalf of the second and third respondent. Then the CGP accepts notice on behalf of the first respondent. The fourth respondent gave it to this on record. Petitioner to serve copies of the writ petition on the council correspondence 1 to 3. This is on 28 presentation of interim relief. The government advocate shall secure instructions. Secure instructions. Executive council government to secure instructions by next week of your yes. 20. Huh? Monday with 28th will dispose it.
Number 22, Naveen Kumar, party person.
ಇಂಗ್ಲಿಷ್ ಬರುತ್ತಾ? ಯಾವ ಪೋಸ್ಟಿಗೆ ಅಪ್ಲೈ ಮಾಡಿದ್ದೀರಾ? ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಕರೆಕ್ಟ್. ಯಾವ ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಯಾವ ಸಬ್ಜೆಕ್ಟು? ಪೊಲಿಟಿಕಲ್ ಸೈನ್ಸ್. ಇಂಗ್ಲಿಷ್ ಬೇಡವಾ? ಇಂಗ್ಲಿಷ್ ನಾಲೆಜ್ ಬೇಡವಾ ಪೊಲಿಟಿಕಲ್ ಸೈನ್ಸಿಗೆ? ಇಲ್ಲ ರೀ, ನೀವು ಇಲ್ಲೇ ನಮ್ಮನ್ನೇ ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೇ ಮಕ್ಕಳನ್ನ ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡ್ತೀರಾ? This is the way you dress up. You want to be an assistant professor. Look at your dress. Don't you have a dress code? Huh? Age relaxation. ಯಾಕೆ? ಏನಕ್ಕೆ ಕೊಡಬೇಕು ಹೇಳಿ? ಹೌದಾ? ಯಾವಾಗ ಯಾವ ಡೇಟಿಗೆ? 8/2020. ಏನ್ ಏಜ್ ಲಿಮಿಟ್ ಏನು? 40 years. In service 45. ನಿಮಗೆ ಏಜ್ ಎಷ್ಟು? 8/7 ಅರ್ಜಿ ಕರೆದಿದ್ದೀನ. ಏನಂತ? ಎಲ್ಲಿದೆ ನೋಟಿಫಿಕೇಶನ್? ರಿಕ್ರೂಟ್ಮೆಂಟ್ 30/9/21 ನೋಟಿಫಿಕೇಶನ್ ಬಂದಿದ್ಯಾ? I think we will permit government. We will permit him to take the exam.
Yes, my lord.
Yes, we will permit him to take the exam subject to result in the writ petition.
Yes, my lord.
Where is the earlier 2020 notification ಎಲ್ಲಿದೆ? ಇದೆಯಾ? ಶ್ರೀ 1200 ಪೋಸ್ಟ್ ಖಾಲಿ ಇದೆ ಅಂತ ನೋಟಿಫೈ ಮಾಡಿದ್ರು ಅಂದ್ರಲ್ಲ.
See, my lord.
ತೊಂಬತ್ತಾ ಏನಿದು
ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡಲಿಕ್ಕೋಸ್ಕರನೇ ನಾವು ವಿಶೇಷ ನೇಮಕಾತಿ ನಿಯಮವನ್ನು ಮಾಡಿಸ್ತೀವಿ. ಅನಂತರ COVID-19 ಇದಕ್ಕೋಸ್ಕರ ಅದನ್ನ ಸ್ಟಾಪ್ ಮಾಡಿದ್ವಿ. ಆದ್ರೂ ಕೂಡ 5/8/2020 ಮತ್ತೆ ಕಮಿಷನ್ಗೋಸ್ಕರ ಕಾಲ್ ಮಾಡಲಿಕ್ಕೋಸ್ಕರ ಹೇಳಿದ್ರು.
ಎಲ್ಲಿದೆಯಪ್ಪ ಎಲ್ಲಿ ಓದಪ್ಪ ಎಲ್ಲಿ ಓದ್ತಾ ಇದೆಯಾ Joint counsel for the petitioner, the learned HCG. The petitioner who is a lecturer, who is working as a lecturer in political science before the court being agreed by the order of the tribunal. The case of the petitioner is that the age of applicants for the post of assistant professor, which came to be for which applications have been invited under a notification dated 30/9/2021.
Case of the petition is that the age of the applicants for the post of assistant professor for which
pursuant to the notification dated 30/9/2021 requires to be extended. It is the case of the petitioner that rules came to be framed in 8/7/2020, and on the said date itself, the vacancy of 1,248 posts was notified, and that the rules were specifically framed in that direction, and that had the examinations been held in time, the petitioner who just what is who has just crossed age of 45 years would have been eligible. It is not in doubt that the COVID-19 has thrown out of life in the last couple of years. There is also no dispute with regard to the fact that that even public exams and any event that led to the congregation of people has been prohibited. And now the state has issued the notification on 30th of September 2021. Had the examinations, prima facie, we are of the view that had the examinations been held in time, the petitioner would have been qualified to attempt or take part in the examinations process, take part in the process for selection to the post of assistant professor, the recruitment process. That we have the matter, we are of the opinion, we are of the prima facie opinion that no harm would be no prejudice would be caused to the respondents if the petitioner is permitted to participate in the permitted to submit applications and participate in the recruitment process. It is made clear that the participation of the petitioner in the recruitment process would be subject to the final orders of the writ petition. Petitioner to appears for the examination authority. K. Ramesha. And HCGP accepts notice on behalf of respondents 1 and 2. Then it counsels to N.K. Ramesh is directed to take notice on behalf of the third respondent. The order be communicated, today's order be communicated to the respondents. Petitioner to shall furnish copies of the petition to the learned HCGP and to the learned counsel for third respondent N.K. Ramesh. ವಕೀಲರಿಗೆ ಕಾಪಿ ಕೊಡಿ, ಪೆಟಿಷನ್ ಕಾಪಿ ಎಲ್ಲ ಸರ್ಕಾರಿ ವಕೀಲರಿಗೂ ಕೊಡಿ. ನಿಮಗೆ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಅರ್ಜಿ ಕೊಡಕ್ಕೆ ಮತ್ತೆ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಭಾಗವಹಿಸಕ್ಕೆ ಆದೇಶ ನೀಡಿದ್ದೀವಿ, ಆಯ್ತಾ? What is the issue, Mr. Somebody is posted, but I didn't send one, and I have no posting. Take 106 straight from. You know, there's one administration. You depute him, and then brought refund in the service. This is the order of the children. They changed the order. When is it? No, you are running. No reason for that. Subsequently, it is approved. Why did they say 55? But you know this. Question built up not only by special department. And so this report said not only special department can report by the page 101. Was he appointed as a? It was the Chandra Naik posted there. I am posted there. Chandra Naik posted it. Huh? I am posted there for 2021. Not page 20. Huh? Chandra Naik posted it. Chandra Naik was working there. Correct. When was he sent there to that post? 4 years. 4 years. 4 years. That was his post. My order is not 18 to 21. Pay 10. Direct petition state government to continue me. Was I completed 4 years. I have completed 10 months to that. Pay 101. I am not in the care of additional director of police. But I have been quoted as not technically handled to 21 on 26 to 21. Within about 10 months, I again now this report that my service shall be continued. Let me take. Within about 10 months, I wrote 41 on KS officer. That's the way. I posted that order. Because this was the administration. They completely my reputation. Law primage. Yes, government. Where is the earlier order of this court?
Before that, you must. Question that I conflict with the reason. Everybody sit down. What it will take, the secretary will take, you can respond to the order. Respond to this not. Question that I want. DPR passes this order directly. You can have no post plot to post everybody. Because it is a post plot. In this part, what is that? And one plot I have become now. Not putting. I will say it. You know, there's a to be at a problem. But run the administration.
Yeah, what is this? Okay. Yeah. Petitioner who was posted as Secretary Central Relief Committee, Bangalore, 26/2/2021. Has been displaced by order dated 5/1/2022, despite an order of this court dated 18/6/2021. If you are the matter, there should be a stay of the operation of the order dated 10/2/2022, rendered in application number W12 of 2020. Stay of the and if you don't stay the, it's okay if you don't stay the tribunal order. Stay the tribunal order, it will suffice because there's a direction in the tribunal order. Yes. Please read. Before instructing, read the petition. ಕಿವಿ ಕಚ್ಚೋದಕ್ಕಿಂತ ಮೊದಲ ಪೆಟಿಷನ್ ಓದಕ್ಕೆ ಹೇಳಿ ನಿಮ್ಮ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್ಗೆ ಆರ್ಡರ್ ಓದಕ್ಕೆ ಹೇಳಿ ಅದು ಏನ್ ಬರ್ದಿದ್ದಾರೆ ಅಲ್ಲಿ ಅಂತ. ಡೆಪ್ಯುಟೇಷನ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ರೀಪೋಸ್ಟಿಂಗ್ ಆರ್ಡರ್ ಕೊಡಿ. Notice.
24. I appear for the petitioner in item number 24, my lord.
One minute. Issue notice to the emergency notice to the respondent that AGA takes notice for respondents 1 and 2. The first respondent to communicate the tendency of this petition to the
24.
I appear for the petitioner's counsel. It is a case of inquiry initiated in respect of that APP recruitment, which my lords have stayed and subsequently Supreme Court has stayed, my lords, by order dated 18/2/2022. Supreme Court has ordered that they not to proceed with the department inquiry till the SLPs are disposed of. Here there is one additional ground also. I am a Group B officer. Lokayukta assumes jurisdiction and Lokayukta initiates suo motu investigation. Just for the sake of the pointing out how the Lokayukta assumes jurisdiction, my lords would kindly turn to page 104. It is my specific contention, my lords, that section 7 is breached. Government writes a letter to Lokayukta that no work connected with this recruitment was ever entrusted to me. That document, my lords, is at page page 76.
Gopal, Friday there was one case where that officer was not working in the post at all. Inquiry is ordered. Entrustment is sought. Entrustment given. 15 years gone.
And dismissal impose matter, sir, last week. And tribunal would have held that punishment is valid.
Do not, we are unable to decipher what is the going on.
Not seen that.
How can an officer who was not even working there?
Illi,
in charge, how can he be inquired again?
Investigating officer writes to the government.
Commissioner is summoned. Commissioner comes, orally admits in the court, yes, officer was not working. So we directed him to file an affidavit. He doesn't file an affidavit. We impose cost of 25,000. After 1.5 years, he files an affidavit. Yes, he was not working. He was project. He was not working at the He was not working in that post. He was discharging duty as project manager.
Papa, he is worried about.
No, if the officers adopt such a attitude, they can be in the same position.
Though all of them are called public servants, they are concerned about their promotions also.
Private interests. Public servants promoting private interests. Yes.
Page 7.
Near the order. Near the order. The head the Learned Senior Council.
This matter.
The order dated. The order dated 18/2/2022, clarifying the position. 18/2/2022 by the Honorable Apex Court, clarifying the position. We deem it appropriate to grant an interim order. What are the connected matters? No?
Stay of inquiry pursuant to Annexure A7.
My lord, that is so far as the APPs are concerned, my lords, he is the main person, my lords, allegation against whom, my lords, forged the signature and carried the bundles of the paper, and even the district judges are.
So you can conduct the inquiry independently. Can you conduct an inquiry against the petitioner independently?
If my learned friend wants to argue on merits, I am ready. I will point out page 104.
No. Rajgopal.
Lokayukta assumes a suo motu jurisdiction.
Madam, please answer us.
Yes, my lords.
Without even reading section 7(1)(b).
Will you be able to proceed with the inquiry without the APPs?
My lords, it's not a thing, my lords. Here, the contention, actually, this matter got linked with the APP's matters, my lords. Thereafter, they got de-linked. Now, my lords, virtue of that APP's, my lords, stay order, this petitioner seeking the stay, my lords.
Sorry, my lords, I am not seeking on that basis.
After 21.3, matter is directed to be listed on 21.3. We will list it after that latest. Where are the other petitions? Okay, you give the number. He passed some orders, no?
That, my lords, that order I also have placed on record at page 255. Writ petition number 2322 of 2020.
It's appropriate.
Am I audible, my lords?
Council, you were mentioning about that Kalburgi. Can you give us that?
Page 255 ಅಲ್ಲಿ ತಾವು ಮಾಡ್ರೆ entry ಮಾಡ್ರಿ.
Yes.
Yes. And
Yes,
here,
ma'am.
my lords, Lokayukta does not even read section 7(1) clause B. Kindly see page 104.
Okay, exactly.
On that page only entire writ petition will have to be allowed.
Yes, we'll hear it on 28th March.
Grateful. If my learned friend has any objection about linking with that separately, ನಂಗೂ ಒಳ್ಳೇದೆ. ನಾನೇನು ಬೇಗ ಮುಗಿಲಿ ಪಾಪ ಸಾಹೇಬ್ರ ಕೆಲಸ ಇವತ್ತು ಅಂತ ಹೇಳಿ ನಾನು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ರೆ ಅದು ಇದು ಬೇರೆ ನನಗೂ ಗೊತ್ತು. I am not the beneficiary of the fraud.
Yes. I know Mr. Rajgopal never shies off a fight. Sometimes they underestimate, they don't realize that you are a seasoned warrior.
Not that, my lords, I am warrior video. ತುಂಬಾ ಗಾಯಗಳಾಗಿದೆ, ಬೇರೆ ವಿಷಯ. Even when I don't want to fight, they force me into a fight. I did not want to tell that Lokayukta has not read section 7(1). Now she is forcing me to say that.
Yes, on 21st we'll appreciate it. 28th, yes.
Great. My lords, the next matter. My lord, this is a case, my lords, where I was working as surveyor on deputation to BDA. Then, my lords, on a complaint of the landowner that I have given a distorted survey sketch. Lokayukta initiated an investigation, and my lords, when the report was submitted under section 12(3), matter was referred to BDA. BDA's reply is at page 80, where they say that the entire complaint is a false complaint. That is not even looked into by the state government.
Ashwin, after the complainant has already availed of a legal remedy. After he having availed a legal remedy, can he still proceed with the complaint? That is what the provision says.
Kumar Minerals Exports Limited, this honorable court has considered that aspect. Where there is a remedy in law.
See, that is why the High Court has interfered and remedied the situation. Merely because there is an omission, can that be the ground to infer criminality? Even the judges write a judgment, one side will say the judges favored the other side. Can every judgment become actionable? Can there must be some substance. There must be some material to show or substantiate the allegation, prima facie. Or it must be so glaring. It be so glaring that no other inference except an adverse inference can be drawn. Which surveyor? How is that survey final? What legal impact does that survey have? When was that survey done?
Lord, that survey was done according to them.
Prior to the notification or after the notification?
That is, my lords, after the notification.
If
And
it's after the notification, what legal implications flow from it?
and my reply, my lords, to that is at page.
While identifying the lands. Huh?
It was not part of the application. He has prepared the stamp for
What was the extent acquired? How do you say? How do you elect? There could have been a mistake in the this one. Whether it is genuine or not, whether it is deliberate or not, how do you say it is deliberate?
After judgment of this honorable court,
it is the reasons by the KIT cannot be a ground. Substantiation, you should substantiate it.
KIT ಯಾರು ಸರಿ ಇಲ್ಲ ಅಂತ ಇಲ್ಲಿ ಬಂದಿದ್ದು ನಾನು.
Why should you go through an inquiry at all? But every action is going to be viewed as a colored action, or you're going to attach any. See, that is the reason why today officers are not willing to take up any work. Anything and everything at the drop of a hat, they say you go to the court, get an order. If you see the rejection or endorsement being given by the executive, it is pathetic. How do you expect them to work? How do you expect them to discharge their duties? Unless you can show that it is palpably offensive. Otherwise, which officer will work? Every action is going to be, looked at with suspicion, and you are discouraging the bureaucracy also. What is the material? What material is there to show that yes, this is done for extraneous consideration? Yes, you, Mr. What was the total extent notified under the scheme for implementing the scheme? Only 5 acres. Forget the individual survey number. See, this is the problem. See, now more than 1,000 acres was notified, correct? 4,000 acres was notified. Out of that, if there is an error for respect of 5 acres or 1 acre, who do you treat it as? And what benefit does he get by showing it as a land that is notified? What benefit does he get?
Instead of showing his land as not notified, he has shown the other person's land as not notified, shown as the complainant's land as notified. That is the allegation that he is making.
Correct. That is an error. How many acres has he surveyed? How many acres did he survey? Tell me. And then it is human to err. There must be some margin for error. You cannot pick up on every error. Yes, unless it is deliberate, it is for a quid pro quo. It is like, once somebody is convicted for 302, you hang him because death penalty is granted. is available, we have the power to award death penalty. Can that be the yardstick? Because power is vested in me, I will inquire. Because power is vested in me, I will suspend him. You have to look into the surrounding circumstances. Whether it is deliberate, it's a deliberate act. Yes, you want to proceed against him, it is understandable. But out of that 4,000 acres, probably must have surveyed some 400 acres. It's either in survey also. How many surveys are there in BDA? How many surveys were employed in that project? But you must look into all that before you all. The drop of an hat, if it is going to be referred to. And is there any material to show that it was deliberate? Prima facie, any material is there. Inside in the ಬಿಡಿ ಕೇಳಿದ್ರು ಕೊಟ್ಟು ಅಂತ ಹೇಳ್ತೀರಾ ಅವ್ರು ಕೇಳಿದ್ರು ನಾವು ಕೊಟ್ಟು ಅಷ್ಟೇ Ask and thou shall not be denied. What is Rajgopal? Ask and thou shall not be denied.
BDA commissioner ಬರೀತಾರೆ. Every one of these allegations are wrong.
And why does he hand over?
And he writes that the complaint is bogus anta.
Complaint, look into the surrounding circumstances.
He explains how things have happened and tell.
Correct, but the senior counsel is saying that your commissioner has written. You should look at all this. This is all unnecessary litigation unless there is material. See, the negative aspect of this approach is that you will be scaring off officers from discharging duty. Everybody will, find an easy way out. Apart from that, they're going to be, if officers are going to be hauled up for performing their duty, then by itself will become a deterrent.
Complaint is ಈಶಾನ್ಯ ಭಾಗದ ಮಾಲೀಕರೊಂದಿಗೆ ಶಾಮೀಲಾಗಿದ್ದಾರೆ. Now the allegation would be commissioner ನನ್ನ ಜೊತೆ ಶಾಮೀಲಾಗಿದ್ದಾರೆ.
ಕಮಿಷನರ್ ಮಾಡಿಲ್ವಾ ಇನ್ನು?
ಮಾಡಿಲ್ಲ ಅವರು, ಯಾಕಂದ್ರೆ IAS ಅವರಿಗೆಲ್ಲ ದೇ ಆರ್ ಸೇಫ್, ಐ ಆಮ್ ಸೇಫ್ ಅಂತ ಅವರಿಗೆಲ್ಲ ಸಿಗೋದು ಗ್ರೂಪ್ 3, ಗ್ರೂಪ್ C, ಗ್ರೂಪ್ D ಇವರೇ ಸಿಗೋದು. ಗ್ರೂಪ್ 1 ಸಿಗೋದು ಅಪ್ರೂಪ್ವೇ. IAS ಆಗ್ಬಿಟ್ರೆ ಅದು ಬಿಯಾಂಡ್ jurisdiction.
Yes, what do you want to say? Then any material you wanted to show some material? Huh? Yes. What is my next step? This is all. There must be some material prima facie to show that either he was benefiting or he had an interest, something like that. Yeah, A jagana B torsi, B jagana A torsidre, he is not going to get any benefit directly unless you can demonstrate that he had a relationship with B. So he wanted to benefit B, so he wrongly earmarked the land of A. If there's any such material, if there's any such substance, perhaps this material, if you proceed, it is understandable. Then everything on first principles. Punishment cannot be reviewed. Appreciation, you cannot reappreciate evidence. But Mr. Rajgopal itself will argue. Yes. What do you want? Friday.
Great.
Friday. 4-3. 4-3. The Managed Senior Counsel and the Counsel for the fourth respondent. Request of the fourth respondent to fourth respondent. We have gone through the hearing the prima facie the allegations that appear to alleged to stand on. But I would make the learned counsel for the fourth respondent is trying to place material to demonstrate and produce such material. This hearing is adjourned to 4.
26, December 26, government case.
Where is this? ನಾವೆಲ್ಲ ಡೀಟೇಲ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಬರೆದ್ರೆ ಅದನ್ನ ಫೋನ್ ಮಾಡ್ತೇವೆ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಬರ್ಬಿಡ್ತಾರೆ ಡೀಟೇಲ್ ಆರ್ಡರ್ ಎಸ್ ಗವರ್ಮೆಂಟ್
were initially appointed in the Department of Forest, were on deputation to Forest Development Corporation. But they were
ಡೆಪ್ಯುಟೇಷನ್ ಆರ್ಡರ್ ಇಲ್ಲಿ
the Forest Development Corporation itself says that they were on deputation.
That is not the correct approach. Don't tell me that Forest Development Corporation and Forest Department have no rules, regulations or procedures. Because
Yes, there are.
when they have, they are running an office. How do you presume things? Correctly, it's not a one-time affair for us to take a sympathetic view. We do not know for how many years we will be fasting them with the liability. Matter requires consideration. What requires to be considered for pension? If somebody is being directed to grant you pension, it must be shown, employer-employee relationship must be shown. That the qualifying period service must be demonstrated. If you are aspect illa andre amela, where is the question of issuing any directions or anything? No, but were they on deputation or were they at the time of formation of the corporation?
They were all signed along with the assets.
Then you have opted option. Records iruttala ellide. They would have exercised an option.
They have received all the benefits.
Oh,
Provident under government.
correct. That is one other aspect of the matter. But they would have exercised an option when the corporation was formed. You can secure it. The corporation also will have a copy of those proceedings. They would have given them options. Options would have been given to you. See, when you wanted, when they started, it was all.
Corporation itself has recommended our case for request
Satish, Mr. Satish, that's it about this forest development corporation. Yes, I gave the learned HCGP and learned council for the corporation to produce records regarding the terms of appointment of the respondents. Yes. Yavabeko, 4-3. Hey. Rubber plantation ಇದೆ ಎಷ್ಟು ರಬ್ಬರ್ ಪ್ಲಾಂಟೇಶನ್ ಇದಾವೆ ಇರೋದು ಒಂದೇ ರಬ್ಬರ್ ಪ್ಲಾಂಟೇಶನ್ ಮಂಗಳೂರಲ್ಲಿ ಮಂಗಳೂರು ಸೈಡ್ ಕಾಸರಗೋಡು ಸೈಡ್ ಮತ್ತೆ ಎಲ್ಲಿ ನೀವು ಎಲ್ಲಿದೆ ರಬ್ಬರ್ ಪ್ಲಾಂಟೇಶನ್ list on 14-3. Substantially heard.
Allegation pertaining to not disproportionate assets, can it be inquired into by not the proprietor or the person? Can rely upon what the employers
today. What is the urgency? Matter requires hearing. You are agala. Next week. No urgency. What is the urgency? What is the urgency? Oh, no.
ಶಿಲ್ಪ ಬರ್ತಾರೆ ಎಲ್ಲರಿಗೂ ಗೊತ್ತಿದೆ, ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲ ಮೇಡಮ್, ಇವಾಗ ಇಲ್ಲಿ ಬರ್ತಾರೆ, ಫಿಸಿಕಲ್ ಬೋರ್ಡ್ ಬರ್ತಾರೆ. ಇಲ್ಲ ನಾನು ಹೇಳಿದ್ದೆ, ನನಗೇನಿಲ್ಲ, ಅವ್ರು ಮಾಡಲಿಲ್ಲ ಅಂತ ನಾನು ಮಾಡ್ಕೊಡ್ತೀನಿ. ಯಾಕಂದ್ರೆ ಮೇಡಮ್ ನಾನು ಭೂತತ್ತಿಗೆ ಹೆಲ್ಪ್ ಮಾಡಿದ್ದೀನಿ. ಕೆಲಸ ಮಾಡ್ಬೇಕಲ್ಲ.
ಮಾತಾಡೋದು ಎಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ
Yeah.
ಇಲ್ಲ ಇಲ್ಲ ಆಯ್ತು, ಊಟ ಆಯ್ತು ಹೇಳ. ಹಾ ಬಂತು ಬಂತು. ಹ್ಮ್ ಸೀರಿಯಲ್ ಅಂದ್ರೆ ಮೇನ್ ಲಿಸ್ಟ್ ಮುಗಿದ್ಮೇಲ ಹಿಂಗೆ. ಇಲ್ಲ ಇದು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ, ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ನಂಬರ್ ಬಟ್
Pregnancy field, maybe in coming months they'll check for the significance and based as he said for therapy cessation, validity of the case. So please be vigilant when you
Let's see, today it may finish. We will, time permits, we'll take up today. I think there's much. Yes.
matter.
ಬಂದಿದ್ದಾರೆ ಇಲ್ಲ ಅಷ್ಟು ಕರ್ದು 5 minutes time.
Cargo matter. Number 4.
Appealing for the petitioner, Your Lordship.
Yes, where is the affidavit?
They have to file affidavit, my lord.
Counter file ಮಾಡಿದ್ದಾರೆ.
Said you will file it here. That is why we passed it over.
The 3 times they have taken time, my lord. I can have it tomorrow, my lord. I'll have it tomorrow, my lord, because second time transfer proceedings is going on, Your Lordship.
Friday.
Much of lord.
Appear for the petitioner.
Proceedings of the inquiry investigation. That order itself, you will see, original government record, public records as per index are received by case of that. Articles of are prepared, sent the same to DEO for appearance before this authority in person on 500 That order is passed on 28/12/2017.
You will furnish a copy to him.
No, my lord, not today.
Memo ila kodi. Presentation form is also.
Friday, my lord.
25 to Friday. Number 6. January 6.
Appear, my lord.
Yes, where's the file? What is there in the file? What is the material in the file? At least have you seen what is there in the file? You nodilla. Excellent work. Call that lady. Yes, madam. Funny. What material is there? Come here, speak into the mic. Can this person Manjunath. Our newspaper ಅಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ರೆ ಹೇಳ್ತಾರೆ. Is there any material to show that he has given? Where is the material? News channel clipping allama. Now they have produced a letter.
Annexure A10, my lord, page 118.
What is wrong? He has received a complaint. He has inquired. ಅವ್ರು ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ ತಪ್ಪ? ಕರೆಕ್ಟ್ ಅವ್ರು ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ ತಪ್ಪ? Okay. So what is wrong? What is the mistake committed by this man? What parallelly, what inquiry he has done? That is not the allegation against him. Allegation is that he has given a statement to the media house. Media ಗೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. ಆ ರೀತಿ ಯಾವ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಮೀಡಿಯಾನವರು ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. What is your take on this? ಮಂಜುನಾಥ್ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಅಂತ ಮಂಜುನಾಥ್ ಬಂದು ಹೇಳಿದ್ರ? Is Manjunath's voice recorded? Then has Manjunath handed over any material? Then ಅದಕ್ಕೆ ಆಕ್ಷನ್ ತಗೊಂಡಿದ್ದು ತಪ್ಪು. ಏನ್ ಸರ್ಕಾರಕ್ಕೆ ಕಳಿಸ್ಕೊಟ್ರಿ ನೀವು?
Now that lady is reinstated, my lord. Strangely, that lady against whom complaint is made, inquiry is in progress, she is reinstated. For having acted, I am suspended.
Is it so?
I have filed a memo, my lord. I have filed a memo. She is reinstated.
Seema reinstated.
Yes, my lord. I have filed a memo. I have filed a memo before the court. It is.
Direct an inquiry how she got it reinstated. Who recommended for a reinstatement? What is going on? This is the third case we are coming across where officer is punished because he has taken action. Where are the records? Who has to inquire into? ಅವ್ರು ಮಾಡಿದ್ ಸರಿನಾ ಸೀಮಾ ಅವರು? ಲಂಚ ತಗೊಂಡಿದ್ ಸರಿನಾ? ಲಂಚ ತಗೊಂಡಿದ್ ಯಾರು ಎನ್ಕ್ವೈರ್ ಮಾಡ್ಬೇಕು? Who has to inquire that act of demand and accepting of gratification? Then what is wrong with what the officer has done? So you want to hush up the inquiry. Then what are you doing? What inquiry is the government conducting? Why has it not been handed over to the ACP? Yes, madam, you volunteer to answer the call. Please answer us. Government andre yaru? Who is the secretary? Food and Civil Supply Secretary. Yes, ask the secretary to be present tomorrow. Take down. HCGP, I learned council for the petition and the learned HCGP. ಅವ್ರದ್ದು ಎನ್ಕ್ವೈರಿ ಯಾಕೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿಲ್ಲ HCGP? Prevention of Corruption Act, ACB Act. What is this, Mr. AG? We are coming across, this is the third case. If action is taken against a culprit who has indulged in criminal action, the government is initiating action against them. Huh? No, we are making a general statement. ACB Act. Delinquent officer who was caught on camera receiving illegal gratification is reinstated. The officer who recommends for action is suspended. And that is not to be justified by you. What is your designation? Controller of legal metrology. I'm told the secretary is conducting an in-house inquiry. Why is it not handed over to ACB? Secretary has powers to investigate. Powers of ACB are vested in the secretary. Which secretary? Food and what is that? Food and Civil Supply Secretary. Secretary Bear. Secretary Bear. See, that is why we asked if the DPA, if the government doesn't want officers to act, let the DPR secretary come and make a statement. He'll record the statement. Everybody can do whatever he wants. Is it not? Yes, the allegation is that some news channel published quoting him. He has not appeared in the news channel. He has not given any statement. No bites are given. Nothing. Somebody, news reporter captures it, videographs the act of the officer receiving the bribe. and he lodges a complaint with the petitioner, who is the superior. So he suspends her. He recommends for action. For that, he is suspended on the charge that you have what is that? Interacted with the media. His suspension option here in such a case. Let us assume he has given information. Is that information, is it a national secret? Does it come under the Official Secrets Act? It's an information that has to be shared under the RTI. And it is the complainant lodges a written complaint. Okay, if it's just a video CD that has to be looked into, we can understand. Written complaint is given. He acts on the complaint. And the officer comes and justifies it. Probably close acquaintance of this officer, that lady. That's why they are feeling offended.
But the learned comes to the petitioner and the learned HCGP.
HCGP. So we'll ask you to assist the court. The learned AAG Sridhan Chenappa is in the court and taking note of the facts involved in the incident case. And this court having come across a similar instance of officer of the government having been punished for having complained or taken action, taken action against a co-officer being punished, co-officer, being punished. We request the learned AG to assist the court. Three facts is that one Seema Maggie. What is her designation? Assistant controller was caught on camera by a journalist while accepting bribe from owner of a petrol bunk. And the said journalist is said to have lodged a written complaint and also copied the video on a CD and handed it over to the petitioner who was officiating the post of controller. He's controller, huh? Manjunath is controller, deputy controller. And on the basis of the said petitioner, after having viewed the CD and the written complaint, said to have recommended for action against the officer by the ACB and is also recommended for suspension of the said officer. It appears that the journalist has telecast, electronic media, na? News first. The journalist of the electronic media appears to have telecast the same. Telecast the same and is said to have referred in the course of the telecast is said to have referred to the name of the petitioner. The department offended by the same has proceeded to suspend the officer, the state petitioner. The petitioner appears to have written to the news channel, appears to have addressed a legal communication to the news channel. In reply, the news channel has also endorsed the, endorse the fact that neither any comment nor any information has been shared with them by the petitioner. Despite the same, where the petitioner appears to have the petitioner has been proceeded against and has been suspended from his duties from his post. He has approached the tribunal. The tribunal, for the easy way out, has said that investigation is underway and hence interference is not warranted, despite the endorsement, despite the legal notice and endorsement by the news channel having been placed before the tribunal. Today we have summoned the second respondent. We have sought for and we have perused the file. Apart from whose proceedings is that? What do you know? Apart from the proceedings recommending action against the petitioner, there is no other material which either which in any way incriminates the petitioner having shared any information or records relating to the offense, the alleged offense. To top it and to add insult to injury, it is submitted by the petitioner counsel, fairly accepted by the second respondent officer who is present before the court, that the delinquent who demanded and accepted illegal gratification has been restored to her post and a suspension revoked. Nothing can be more surreal, surreal and cinematic than this incident. The person committing a crime is allowed to go scot-free, whereas over the superior who complains of the criminal act, the criminal misconduct, sought to be punished. Yes. Probably it is a message to all officers, not to all of officers who indulge in dubious acts. That way of the matter, we request the Additional Advocate General to secure instructions from the Secretary and Civil Supplies Department as to whether this is the yardstick that is being practiced both by the department and or by the government, practiced by the department or by the government, where officers who discharge their duties to be sought to be punished. Second respondent shall place record all material and support it in the same along with an affidavit. In the above circumstances, the order transfer is stayed. The petitioner shall be restored to the post he was occupying immediately prior to the order of suspension. Same shall be complied. This direction shall be complied for. The respondents do not give any further cause for concern. Yes. Ask them to restore him immediately. Carbon copy of this order to be furnished to the learned HCGP.
Cargo matter 8 till rate, commuted rate.
Application also directed modify the SCPDT category which is not permissible. Instead of selection in SCPDT and also to remove the selection of the respondent number 5 who was being selected in the year 17.
Public complaints to the final order. Justice Raghavendra Gayatri is not come today. Yes. Head Milan conflict and then there is the order in June. Compliance of the order will be subject. Compliance and implementation of the order would be subject to the final outcome in the writ petition. Petitioner to send copy of the writ petition on the learned counsel who represented the applicant before the tribunal. File acknowledgement. This is for listed for hearing. Photo. ಬೇರೆ ಯಾವ್ದು? Issue emergent notice to respond 1 to 3. The petitioners are permitted to serve copy of the petition on the counsel who represented the respondent before the tribunal. Yes.
Rule number 49 was interpretation of rule 49.
Nice coincidence. Argument does not require any interpretation. It has already been interpreted.
Sufficiently.
Interpretation is whether 13 rules validly made. So, where's that rule? Rule that is under challenge.
page 674.
Yes.
674 in 2022. We are concerned only with what bill number 8 in the schedule that we at 678. Addition 2, my lord. Must have continued service of not less than 18 months of experience. Manufacturer and or and or testing of schedule C and or C1 drugs included in the drugs and cosmetics tools. Since your options are on this case, also mark serial number 6. I will come to that presently. It is not the assistant drugs controller. The licensing authorities under Rule 49A. You should see the conditions imposed.
Where is the earlier notification? 2002.
Right with the memo. That reference was I request your lordships on that page just mark clause 6 before I come to 2000.
Which page?
On 678. Is at 677. Assistant drugs controller by promotion. The Father of Drug Inspector. The student not has title of service, the Father of Drug Inspector. Why did the officer that put in service or not available in 5 years? Or are not available in office?
670? 670?
7. Number 6.
Okay, no.
Assistant drugs controller by promotion to Father of Drug Inspector. So today not has been 5 years of service in the Father of Drug Inspector over the page 2 months. Must have the qualifications specified under Rule 49 of the Drugs and Cosmetics Rules.
The 49A.
49A, sorry, 49A. Now here we not say body lift 49A and say that the requirement of the 49A shall apply to a licensing authority, the ADC. But when it comes to the drug inspector, they travel far beyond 49. That's in number 8. So the state is conscious, Lord, that these officers are to be appointed as per the qualifications prescribed under the Drugs and Cosmetics Rules. The error that they have committed is when it comes to drug inspectors,
serial number 2 at the minimum qualification column. They have traveled beyond 49 and made a post-appointment requirement a pre-appointment qualification.
Kind of this is the entry level post.
Yes.
This is the garden for trucks ADC.
ADC is licensing authority under 49A. Because these authorities, if you want to see 49A for the moment,
What do you mean?
Just like 49 says about qualification of the inspector, 49A says qualification of the licensing authority. When it comes to the licensing authority laws, they apply it completely in the state rule. But as far as this Clause 8 is concerned for drugs inspectors, the state has sought before your lordship to argue that the power is traceable to not the Karnataka Civil Services Act, and thereby allows to entry 41 the list 2 Constitution. But this aspect is directly answered by the judgment of the Honorable Supreme Court in post-pharmaceuticals. They are facing those First point out, before the case act, the state did not take a stand. Was never their contention that this is a case of power being traceable to this too. The only submission on this constitutional aspect was made by the APSC alone, para 76 of the case act order. And APSC interestingly argued that the power is traceable to Article 254. And because presidential assent has been received to the Karnataka Civil Services Act, the state act will prevail. Which may not para 76 of the order of the case act. And we make a lot of that. Can do that before I proceed to the judgment. Just for a moment. Is there. Page 702 of volume 3 notes. Para 76 at page 802. The learned senior counsel for APSC, page 802. Learned senior counsel for APSC has specifically contended that the repugnancy stated by the learned senior will not apply to the case of recruitment rules of the state because the same have been made under the Karnataka State Civil Services Act, which has received the assent of the Honorable President on so and so, and has come into force on so and so on its notification by the state government. It is pertinent to mention that the judgment in Satyapal Reddy itself makes an exception to the repugnancy argument in the case where the state makes use of the State Act that has received the assent of the President. Accordingly, we are in agreement with the learned senior counsel of KPSC, based on the apex court judgments relied upon by him, that the recruitment rules made by the state under the Karnataka State Civil Services Act in respect of recruitment to civil force and civil services in the state will prevail, and in the incident case, the qualifications prescribed by the state for drug inspectors are not repugnant to the qualifications prescribed to the DNC rules. Therefore, reliance based on Ashish Kagi is untenable and is rejected. Now this, as also the new stand taken by them before your lordships, that this is really not a repugnancy situation under 254, but the enactment of an act under which both are answered from in most constitutions. And regard to the language of Article 246. I will come to Class 68. This was a case note that a provision under the Bihar Finance Act was questioned as being otherwise the Essential Commodities Act. We may briefly refer to 3 Australian decisions relied upon. As stated above, the decision by engineering company lays down that the inconsistency is also created when one statute takes away rights conferred by the other, or the illuminating judgment of Justice Isaac. In ex parte case, Dixon laid out another test. That is, no two statutes to be said to be inconsistent if they, in respect of an identical subject matter, impose identical duty upon the subject, but provided for different sanctions for enforcing those duties. In stock motor, the Supreme held that even in respect of cases where 2 laws impose one and the same duty of obedience, there may be inconsistency. As already stated, the controversy in these appeals falls to be determined by the true nature and character of the impugned enactment, its fit and substance, nature and character of the as to whether it falls within the legislative competence of the state legislature under Article 246(b) and does not involve any question of repugnancy under Article 254(1). We fail to comprehend the basis for the submission put forth on behalf of the appellants that there is repugnancy between subsection 3 of section 5 of the Act, which is related to entry 54 of this 2 of the 7th schedule, and paragraph 21 of the control order issued by the central government under subsection 1 of section 3 of the Essential Commodities Act, related to entry 33 of this 3, and therefore subsection 3 of section 5 of the Act, which is a law made by the state legislature, is void under Article 254. But I am reading a paragraph 69. Page 45. So please note, Lords, here the conflict was between the provisions of the Bihar Finance Act related to 2054 of this 2 and the provisions of the Essential Commodities Act related to 2033 of this 3. As is the case here. You are concerned about with entry 41 of this 2 and entry 19 of this 3. So identical conflict. Now please permit me to read further. The question of repugnancy.
1 minute, please. 1 minute. Let me catch up with you.
I'm sorry.
Question of repugnance, para 69.
69. Please. The question of repugnancy under Article 254(1) between a law made by Parliament and a law made by the state legislature arises only in case both the legislations occupy the same field with respect to one of the matters enumerated in the concurrent list, and there is a direct conflict between the 2 laws. It is only when both these requirements are fulfilled that the state law will, to the extent of repugnancy, become void. Article 254(1) has no application to the case of repugnancy due to overlapping found between list 2 on the one hand and list 1 and 3 on the other. If such overlapping exists in any particular case, please mark this note. The state law will be ultra vires because of the non-obstante clause in Article 246(1), read with the opening words subject to in Article 246(3). In such a case, the state law will fail not because of repugnance to the union law, but due to want of legislative competence. It is no doubt true that the expression in law made by Parliament, which Parliament is competent to enact in Article 254(1), is susceptible of a construction that repugnance between a state law and a law made by Parliament may take place outside the concurrent sphere, because Parliament is competent to enact law with respect to subjects included in list 3 as well as list 1, But if Article 254 is read as a whole, it will be seen that it is expressly made subject to clause 2, which makes reference to redundancy in the field of the concurrent list. In other words, if clause 2 is to be the guide in determination of the scope of clause 1, the redundancy between the union and state law must be taken to refer only to the concurrent. So what this directly answers both claims of the advocate. Before the case act, the KPSC argued 254. Redundancy is saved because of presidential assent. This judgment clarifies the position that only arises if both the laws are traceable to the concurrent list, which is not the case. The other limb of argument raised before your lordship the first time by the state is that I am placing my power independently to list 2, LG 41. Yes, that power may exist, but when the field is occupied by a central special enactment, namely the Drugs and Cosmetics Act, then to that extent, the state law must be. I am not submitting not that the Karnataka Civil Services Act must go. That power is there. This particular provision
To this extent, to the
extent, only to that extent. And then, if my lords permit me for a moment to read Article 246, the position would be further clarified.
yes.
Subject matter laws made by Parliament and by legislatures of states. Notwithstanding anything in clauses 2 and 3, Parliament has exclusive power to make laws with respect to any of the matters enumerated in list 1 in the 7th schedule in this constitution, the PPM list. Notwithstanding anything in clause 3, Parliament and subject to clause 1, the legislature of any state also have power to make laws with respect to any of the matters enumerated in list 3 in the 7th schedule in this constitution. So 2 notwithstanding clauses. Now please mark 3. Subject to clauses 1 and 2, the legislature of any state has exclusive power to make laws for such state or any part thereof with respect to any of the matters enumerated in this 2 in the 7th schedule in this constitution. So, lords, the power of the state when it comes to enacting legislation in respect of matters enumerated in this 2 is made subject to clause 1 of Article 246. That is the constitutional prescription. And therefore, any power that the state exercises will always be subject to the field being occupied by central legislation, which in this case is the Drugs Act and Rule 49 thereof. Now, this question is also answered in the third judgment in case compilation at page 105, which is the case of A.V. Krishna, 1998 PSCC. What is find this was a case at 107 words. The issue is held up. First paragraph. 107. Those words from the state of Mysore as we were there. Section 39 of the Fire Code Amendment 107. Para 1. Section 39 of the Fire Force Act 1964, under which the Mysore Fire Force has been established, gives rule-making power to the state government, in exercise of which the state government made the Mysore Fire Force Harder Recruitment Rules 1971. Under these rules, promotion to the post of leading firemen is made from the post of firemen or firemen drivers. And this was the dispute that arose. Please come to Class 6. At para 5 lords, the ruling power under Article 309 was relied upon by the state, as is the case here. Please come to para 6. It is primarily the legislature, namely Parliament or the state legislative assembly, in whom power to make law regulating the recruitment and conditions of service of persons appointed to public services imposed in connection with the affairs of the union of the state is vested. The legislative field indicated in this article is the same as indicated in entry 71 of this 7th schedule, entry 41 of list 2 of that schedule. The proviso, however, gives power to the president or the governor to make service rules. But this is only a transitional provision, as the power under the proviso can be exercised only so long as the legislature does not make an act whereby recruitment to public posts as also other conditions of service related to that post are laid down. The rule-making function under the proviso of Article 309 is a legislative function. Since Article 309 has to operate, is subject to other provisions of the Constitution, it is obvious that whether it is an act made by Parliament or the state legislature which lays down the conditions of service, or it is a rule made by the president or the governor under the proviso to that article, it has to be in conformity with other provisions of the Constitution, especially Articles 14, 16, 11. The fire services under the state government was created and established under the Fire Force Act 1964, made by the state legislature. It was in exercise of the power conferred under Section 39 of the Act that the state government made service rules regulating the conditions of fire services. Since the fire services had been specially established under an act of legislature, and the government, in pursuance of the power conferred upon it under the Act, has already made service rules, any amendment to the Karnataka Civil Services Rules 1977 would not affect the special provisions validly made for fire services. As a matter of fact, under the scheme of Article 309 of the Constitution, once a legislature intervenes to enact a law regulating the conditions of service, the power of the executive, including the president or the governor, as the case may be, is totally displaced on the principle of the doctrine of occupied field. If, however, if any matter is not touched upon by that enactment, it will be competent for the executive to either issue executive instructions or to make a rule under Article 309 in respect of that matter. Not an almost identical scenario. This was a case where the Central Act was the Fire Services Act. Rules were framed by the state government in that case. They sought to amend it by making an amendment to the Karnataka Civil Services Rules. And the Supreme Court held that could not be done because the field was occupied by a special enactment. That is, namely, in that case, the Fire Services Act. In our case, what the Drugs and Cosmetics Act. And therefore, whether you place it to 309 or you place it to NP 41 makes no difference. That has to yield to this special central enactment. And just over the page, I may point out that paragraph 13 to the above effect is also the decision of this court on premiums. The above effect is also the decision of this court in Maharaja Pratap Singh Bahadur, in which it was indicated that an earlier special law cannot be held to be abrogated by mere implication. That being so, the argument regarding implied supersession has to be rejected for both the reasons set out above. And finally, note that paragraph 15, as pointed out earlier, fire services were created and established under the Fire Force Act 1964, made by the state legislature, namely the fire services, which gave rule-making power to the state government. Instead of amending the general recruitment rules, the government could well have exercised its power under Section 39 of the Fire Force Act 1964 and amended the rules specially made for the fire services. The government, however, in its wisdom, did not do it obviously because it never intended to touch the fire services specially created by the state legislature. Lords, here, your Lordship just peruse the language of Article 309 for one moment. The position, Lords, is made clear from the language of 309 itself. recruitment and conditions of service of persons serving under the union or the state, subject to the provisions of this constitution, acts of the appropriate legislature, please mark this, may regulate the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the union or of any state. So, my lords, the appropriate legislature for the purpose of drug inspectors is the union government. It may be generally, my lords, for other posts under the state government, the Karnataka Civil Services Act will apply. No dispute with that position. But when it comes to this statutory post, it is not the central legislation that has come to be passed as a special law under 309, read with Lords 2019 of this degree. And this position is clear from section 21, which your lordships have seen repeatedly. The 21 lords, the inspectors may be appointed, the central government or a state government may, by notification of the official gazette, appoint such persons as it thinks fit. So whether it is a drug inspector being appointed by the central government or by the state government, in both cases 21 will apply.
The point is there.
Please.
Power to prescribe qualification.
It says in 21. Having the prescribed one. The central act deals with both. And the qualification being left to the state or not, then there could be no quarrel. And that is where Satyapal Reddy's case comes in. I will presently come to that.
Yeah, I was, in fact, Mr. Chowta is picking up where every chapter rule making power is reserved to the central government. The central government has a Drugs Act.
Yes. Here it is.
Motor Vehicles Act, it is shared between the state and.
And you are also
13 specifically empowers the state.
Empowers 213(4), and it only says the minimum qualification may be prescribed by the center. So that is a direct, not license to the state government to do what it must. It is here, consciously, not 21. Right with the rule making power lots under 33 leaves no scope for the state government to travel beyond it. That towards the Drugs Act is a
that is the hurdle they'll have to get over, because apparently the rule making power is retained by the center, by the union, under the DHC Act. And furthermore, there is a mandate of the Act that it shall be placed before the Parliament. The very word that it shall be placed before Parliament is indicative of the fact that the rules have to be framed by the center.
Okay. That's
not place it before.
Only thing state can do. Which they have not done. I'm so grateful. Is to go under 254, make a Karnataka Drugs and Cosmetics Act, Amendment Act, place it before the
occupied field.
No, if they get presidential assent, so they will. It seems Maharashtra has done it. In fairness, I must place it before your lordship. Maharashtra has done it.
Maharashtra, one of the cases that it is looked at as additional qualification. What are the
just to, for the sake of completion,
as an additional qualification?
Yes. You have to see this memo. Page 5. Of course, I don't think this has been questioned in any court of Maharashtra Act.
No, it is not. No, see, the Bhutas was on the other foot there. There, a candidate came up, petitioner came up, demanding that experience be stipulated as one of the conditions, qualifying condition. It is the other way around here. There, the Supreme Court said, Apex Court said, it's an additional qualification. The High Court took a view. No, you must stipulate experience as a condition. Apex Court has disagreed and it has said
notice to the case of reference.
As a additional qualification.
And in case of reference, which are referring to Varade, in case of reference, let us come to that. We see this Maharashtra amendment on page 5. Drugs and Cosmetics Maharashtra Amendment Act 1989. This act received the assent of the President from so and so. Assent was published in the Gazette from so and so. An act further to amend the Drugs and Cosmetics Act 1940 in its application to the state of Maharashtra. And they have not brought in an amendment in section 2 thereof by providing some changes, cosmetic changes to the Cosmetic Act, such as fees payable, etc. 33 1A has been inserted.
You have an act of the state also.
We don't have. They have Maharashtra. We don't have a Karnataka. I'm only showing this to say that if at all Karnataka had to do something, they could do
So
something.
whether at all they could do it.
If at all,
Enact.
please.
Make an enactment and then
Go
see.
to the president and that assent would not have to be a specific assent.
Yes.
Then they have to place it before the honorable president saying we intend to, as Maharashtra did, provide an amendment of the state over and above what the union has done. And if the assent is provided, it could possibly be saved for under 250. Nothing of that sort has been done here. And if at all, just come one
This
way.
is, it provides for the implementation of the act.
Yes.
You see the it is with regard to fees, etc.
Doesn't chip away at
They have
any.
not tinkered or tried to tamper with the.
Rule 49 has not been tinkered in any state. The states that sought to do it,
Nature of rules.
all the states that sought to do it have suffered orders at the hands of the court. Didi Pandey in Delhi, Kuldeep Singh in Allahabad, Punjab and Haryana. In all those cases, the honorable courts have said you cannot override the central rule.
That is the settled proposition.
Because the state also understands it that way. May I just show at page 1 an extract from the
That's why I asked you for the 2002 rules.
the reference.
Whether it was
2008.
preferential or what.
2008. That is the memo. No, 27 9 2021. Document 1. Page 1. At page 2. Reference. But take the extract from the website, page 1 of the memo that I just passed on. How the state government has understood its interplay with the union government.
It's
This is from the Drugs Control Department. The second paragraph, evolution of Drugs Control Department in Karnataka. Drugs Control Department in Karnataka, as its beginning with the appointment of 4 drug inspectors in the erstwhile Mysore state in the Directorate of Health and Family Welfare. The Drugs and Cosmetics Act 1940 and Rules 1945 were implemented in the Karnataka state with effect from 1/4/1957. Thereafter, over a period of time, more number of inspectors and government analysts have been appointed with ancillary staff for the implementation of the Act. They also see drug inspectors and government analysts as being appointed pursuant to the Drugs and Cosmetics Act and the rules framed thereunder. This is crucial, Lord, because these are the only 2 statutory posts. Under 21, the Lordships have seen it is drugs inspectors. Please, for a moment. See section 20. Government analysts. Here also, section 20, the state government may, by notification, the official gazette, appoint such persons as it thinks fit, having the prescribed qualifications to be government analysts. And in respect of both, under section 33, 2B, the power to prescribe qualifications is not vested in the central government by placing the rules before Parliament. 33 2 notes. Without prejudice to the generality of the foregoing power, such rules may be prescribe the qualifications and duties of government analysts and the qualifications of inspectors. So a statutory exception got made in respect of these two posts. It will not be government analysts and inspectors is there in this system. This is how the state has done it. The Lordships already saw in the recruitment notification also they refer to the government cosmetics group. It's not that they are acting independent of it. In the statement of objections, right before your Lordships in this reputation, that is their because there will be no stoppage against a legal position. But I just want to show how the state has understood. But please see para 10. It is submitted that the petitioner has not preferred his reputation mainly on the grounds that the condition number 2 of the recruitment notification is contrary to Rule 49 of the Drugs and Cosmetics Rules. It is contended that the notification does not say that the conditions with requisite experience in R&D should not be considered as permitted.
But they have done otherwise.
They have done otherwise. It is further contended that during the process of selection, the goalpost is changed. Rule 49 is extracted. Please come to para 12. It is submitted that cadre and recruitment groups trained by the department also prescribe the same qualification in compliance of Rule 49 Drugs and Cosmetics Rules 1945. The recruitment notification also is in conformity with the CNR rules and in conformity with Rule 49 of the Drugs and Cosmetics Rules. This is their understanding. That is the case. From the face of it, your Lordships have seen. And the recruitment you have to go. But that is
When was the notification issued? 18, eh?
2018. Between 2018.
Suppose we accept it. How many applicants were there? Total applicants.
Many of whom may not have applied, seek this information. Set it aside and ask them to issue a fresh notification as per 49. It will also expand the pipeline.
There is also a flip side to it. Somebody may get age bar.
Agrees of public service.
Agrees, somebody has already. Yeah, on that date, whoever it is, they should have come. They have not approached the court. Age prescription irutte. Compulsory irutte. There won't be a notification without age. Yes.
Yes, sir. Just to wrap up, I have just few more minutes to take. That was the Drugs and Cosmetics Act is a special enactment. It has now been settled by the Honorable Supreme Court. Page 61. 2020 doesn't. Queen of India was Kumar Sharma. Not generally. Inspectors brought to the power to exercise the penal powers under the CRPC. What is the interplay between the provisions of the Code of Criminal Procedure and the Drugs and Cosmetics Act? Whether in respect to offences falling under Chapter 4 of the Act, an FIR will be registered under 154 CRPC. Case investigated or whether Section 32 of the Act supplants the procedure for investigation of offences on the CRPC. The taking of cognizance of offence under 190 CRPC. Still further, that the inspector of the Act arrest a person in connection with an offence under Chapter 4 of the Act. From para 11 onwards, the authors will find these statutory provisions are expected. Section 21, which I repeatedly read before your lordships. Over the page, Rule 49, which the lordships have seen, Rule 51, 52. Then not as para 15, section 22, which is the powers of the inspector, various other provisions laws. And then at para 42, the scheme of the Act is in the page 72. The scheme of the Act must be borne in mind. Section 32, which provides inter alia that an inspector can set the ball rolling is considered. The inspectors under the Act.
Where are you reading?
Not para 42, page 72. The scheme of the Act must be borne in mind with Section 32, which provides inter alia that an inspector can set the ball rolling is considered. The inspectors under the Act are to possess the prescribed qualifications. The qualifications therein exist with the performance of the specialized duties which are to be performed under the Act. Apparently, knowledge about the concerned perspective goes a long way in equipping them to perform their multifarious functions. Section 22, clothing the inspector with powers, must also be viewed thus in the context of the legislative value judgment that a complaint is to be moved by the inspector under the Act and not by a police officer under the CRPC. And I will skip that portion to save a lot of time and take the honorable court to para 45. But the early part of 45 is regarding section 32 and the powers of the inspector. Please see about 8 lines in that paragraph. Para 45, about 8 lines into the paragraph. with the words in regard to offences. Got 4 lines from the bottom. In regard to offences contemplated under section 32(3), the police officer may have power as per the concerned provisions. Being a special enactment, the manner of dealing with the offences under the Act will be governed by the provisions of the Act. It is to be noted that section 32 declares that no court inferior to the Court of Session shall try offences punished under the Act. We have noticed that the rest of it deals really with the interplay between the CRPC and this Act. But what the Supreme Court has held over is that the Drugs Act is not a special enactment when it comes to the matter relating not to the Drugs and Cosmetics Act, and particularly the exercise of powers by the inspector. This is reiterated at para 148 onwards. I will not read. Lordship will just mark it. Para 148 at page 100. Page 100. Para 148 onwards. We have noticed that the inspector under the Act has been conferred with vast and formidable array of powers, and an enactment like the Act, the taking of samples, report given, etc. But keeping in mind the vast and formidable array of powers in para 148, and in an enactment like the Act, which is a special enactment, the drug inspectors have been held to exercise powers which would otherwise be exercised by police officers under the CRPC. That is the level to which the drug inspector's role has been recognized. The conclusions your lordships get at page 103. But in regard to cognizable offences under this Act, the police officer cannot prosecute offenders in regard to such offences. Only the persons mentioned in 32 are entitled to do this. All the more reason not the state government must be conscious that fitting persons are not recruited to the post of drug inspectors. They are extending such vast powers now by narrowing the field by providing a post appointment condition as a pre-qualification as they have now done. Schedule C. They are limiting these 5. And your lordships have seen now, in service persons are the beneficiaries. A direct recruitment process has indirectly become a promotion process. And they are the ones who will now rule the roost. And therefore, not looking at it purely constitutionally or even from an administrative law
They will come with another petition. Past service has to be counted for seniority.
Seniority is in promotion.
No, they'll come. Next litigation would be that. Is it done? Ground is ready for the next petition. Fixation after fixation of pay scale.
Mr. Rubin busy.
Oh, Rubin may not be. He'll be busy. State at the Mr. Law. Yes, that's all.
Just 2 more minutes. Occupied between 2 long words. But the process the lordships have seen and did not make any further submission. The APSA is actually more loyal than the king. They have done their utmost to rewrite the notification post facto. They have brought in so-called committee. Even the committee your lordships have seen is at cross purposes. I need not really say any more. Grateful to my colleague, but I should have also.
Oh no, which is the expert committee? whether the two-man state committee or the single-man central committee or the two-man commission committee or ultimately the board. Yeah, we are aware of the saying man proposes, God disposes. But we do not know who is proposing what and who is disposing what.
Many cases in the state officers found us eligible. I had nothing to say. But the central officer had his own view. He brought in his
The two-man committee had its own view.
own view.
Then that was again put before the board and board took its own view. Ultimately, none of them ever bothered about the in-service candidate. And there is no such quota of in-service candidate.
There are a constitutional functioning, but their duty is not towards evaluation.
No such, there is no such reservation, no?
Let's see one line.
Render it to a farce. To show it, but what we have seen is we are not very comfortable with what we have seen. The departmental candidate, they have reduced it to a farce. They have certificates not produced. They don't have the qualification. Randomly, every expert body adopts its own standards, which is its standards of evaluation. Yeah. On facts, you are very bad. Get what clarifications? You can't clarify all this. You can't say anything contrary to what is there and what you have accepted. You have accepted and acted upon that report. Where is the what is it that you're going to clarify?
I should have read one line from para 109 in this Chokma, page 91. The last line was, very qualification, page 91. The very qualification.
The para 109.
109. Last line.
Last line.
The very qualifications which are provided in the rules, that is Rule 49, as indispensable for being appointed as an inspector, represents a carefully chosen value judgment by the legislature to assign the implementation of the Act to the competent hands of qualified persons. The Act is enacted to achieve the highest public interest, in as much as what is at stake is the health of the members of the public, which again is recognized as one of the aspects covered by the fundamental right protected under Article 21 of the Constitution. Keeping this officer out from the categories of person who could prosecute offences under Chapter 4 of the Act is also carefully thought out, I feel. First, what I wanted me to quickly refer to Varade. Just take a minute. Respondent compilation.
It's there.
The case of reference.
ಒಂದೇ
But at para 8, the two clauses that concern us. 4.6, practical experience gained after acquiring qualification above in clause 1 in the manufacture or testing. It said here or testing. The current condition under the recruitment notification, it says and or. I read that in your lordship. Over the page, 4.7 words. Preference may be given to candidates having a postgraduate degree in a subject mentioned in clause 4.5 or research experience in the synthesis and testing of drugs.
which one?
So,
Which one the map?
What is it? 22 to 2025. 9 to. Distinguishing factors was
Yes,
one is
yes,
4.6.
yes.
It's like or. In our case, it says and or. Secondly, in 4.7, preference. This was interpreted very often Supreme Court at Karnataka to say manufacturer is defined as a process for making, etc. And accordingly, had the R&D must be led to a manufacturer. And further at para 30, the preference clause in 4.7 was sought to be interpreted. What is seen in our case, the recruitment notification says nothing about R&D. It in fact says and manufacturing and or testing. So testing stands alone. Once testing stands alone, in the statement of objections, your lordships have seen in para 10 that I presently read, they say the notification does not exclude R&D. If it does not exclude R&D, then how is it that the KPSC at a closed door meeting that they had with some committee members excluded all of us? That's one of the key distinctions. Section 16, power to make regulations. The council may make regulations not inconsistent with this act, including to carry out the provisions of this act, and in particular and without prejudice to the generality of the foregoing powers, such regulations may provide for. Please come to G. prescribing the standard curricula for the training of nurses, midwives, and health visitors, for training courses for teachers of nurses, midwives, and health visitors, and for training in nursing administration, prescribing the conditions for admission to courses of training as a faucet. This is really not an act for prescription of qualifications and conditions for training. And it is in that context not that the Honorable Supreme Court in Suman Devi considered the interplay between this act and the regulations and what the state of Uttarakhand had sought to do under its recruitment rules. Please see para 30. I will close with this submission. In regard to the argument, Suman Devi, issued by the state.
Your compilation.
Yes. 31-1. Serial number 1. In regard to the argument, the statutory rules framed by the erstwhile state of UP as applicable to the state of Uttarakhand were contrary to the provisions of the INC Act. This court holds that the submission to be insubstantial and unmerited. The objective of the INC Act, as indeed its provisions testify, are to set up a central council, that is the nursing council, committed to evolving uniform standards for nursing education in the country, and to provide for recognition of degrees and qualifications of institutions and courses that cater to nursing. In the discharge of its function, the INC has prescribed a mandatory A&M course with a minimum training required. It is undisputed that all the applicants did undergo at various points in time education and training from such recognized institutions. However, that is not the end of the matter. The state, the state in its legitimate role as a public employer is empowered by virtue of the proviso to Article 309 of the Constitution of India to frame appropriate rules. These rules can prescribe conditions of service for various classes of posts and services under the state. The conditions may include a minimum education qualification which the state deems appropriate for a candidate to possess before he or she can compete for a particular post at the stage of recruitment. That the INC Act allows the council to prescribe standards for education which it legitimately exercises for the purposes of recognizing nursing courses in no way detracts, or undermines the authority of the state to prescribe other eligibility conditions which candidates can and should possess as a condition precedent for recruitment purposes in the exercise of power under the proviso to Article 309. So the INC Act did not occupy the field. In our case, the Drugs Act, unfortunately for the state, has occupied the field when it comes to the post of drugs inspectors. Apart from the legal lacuna that the state would not have made such a rule, your Lordship will also consider that the very prescription of the condition was arbitrary and unnecessary. It's not as if the state has tried to improve the.
It may not be. Who knows more if the central government decides so? So saying that it is unnecessary or
Central government not to recall the committee advised dropping the provision. The specialized committee that the advisory board, who has a role to play under Section 33, has recommended that in fact the post
appointment qualification to provisional coordinates.
Because many of prosecutions have failed because of it. That is the fact. Inspections are engineered. The results are also engineered. Everybody has become smart. It's difficult to keep abreast with the obnoxious lot.
So grateful for the education. Some submission was occupied. That is what seems to be the fulcrum of the submission that we advanced by the other side. The state enacts the law on drugs and cosmetics. Then we do the state of Karnataka. It is really occupied. I'm getting dispute about that. Because our drugs and cosmetics act has been enacted by a if not, the state takes the leave or the submits it for the approval of the president.
Not much. Submission.
And not president grants the approval. Then, insofar as the state of Karnataka is concerned, the Karnataka Drugs and Cosmetics Act. That is not what 46 is all about. In this case, of course, there is no dispute about the fact we don't have a drugs and cosmetics act because we are not operating. The question is whether a rule made under a statute, in this case, the drugs and cosmetics rule 49, is made in exercise of what is prescribed in section 21 of the Drugs and Cosmetics Act, can be said to occupy a field. The Lordship are told today that the rules today occupy the field because the rules are made in exercise of a certain power that is vested with the central government under the Drugs and Cosmetics Act in section 21. Rule making power of my special condition was this. The entry with respect to drugs and cosmetics does not take into consideration recruitment to the center, recruitment to the states are covered under completely wholly different entries. List 1, entry 71 to 91. List 2, entry 41 are the lists which determine as to who has power to make recruitment where. That power in a respective submission is not and cannot be exercised either under the concurrent list by the central government or by anyone else. That power I exercise within the state, the central government exercises within the central. But the question is, if the Drugs and Cosmetics Act is under the concurrent list, there can be a prescription of qualification, which qualification should then go and take over my legislative power under list 2, entry 41. So far as not the entry 41 is concerned, I am supreme within the state. Nobody will not can come and say that anyone else can legislate. The real question is that can the central tomorrow say, I have prescribed qualifications, the state is bound to follow those qualifications for appointment of a drug inspector within the state card. I say with submission, it can't be.
The scheme of the Act. The Act is a central act. Scheme of the Act is standardization of the functions stipulated for the drug and cosmetic industry. Now, whatever duties that are being discharged other states will be the duties that you can discharge. You in the sense the drug inspector. Can you assign duties over and above what is stipulated under section 21? If that is not permissible or that is permissible, then if the qualification prescribed by section 49 holds good in respect of the entire country, what is the differential intelligentsia on which you are basing your additional qualification as mandatory? Preferential is something different.
I understand what you're saying. Now, exercise of powers.
One exercise of powers, once you see it is occupied territory, then you are trespassing.
But if you watch it come to the conclusion that concept of occupied field,
It's a recognized doctrine.
occupied field is recognized doctrine. Occupied field, when you watch it, are considering service. At the same time, the same different situation.
It's not service.
It is not
Not this is pre-recruitment.
For recruitment. So what I need to recruit a person is what it is. Really, the question now is, in the guise of drugs and cosmetics fact, can there be translation into another list? It can't be, which is why in Satyapal Reddy this is being examined. Now that has been distinguished by management saying, under the motivating fact to examine it, there is a rule making part of the central government, there is a rule making part of the state government. So that is, in my perspective, highly relevant because that rule making
Can't see you may be right, but unless and until the law permits now the principles of interpretation, we are bound by whatever the apex court has settled. Now the rules of interpretation, something that I don't think this bench can change. It is already settled by the apex court, whether it is a repugnancy, occupied field. It is a field that is which is already occupied by pronouncements of the apex court.
The proposition in this case is the principles of repugnancy and occupied field do not apply. Because if you watch it, what they apply, first of all, there is going to be repugnancy between what I have prescribed in my view and what is prescribed in drugs and cosmetics. There's no doubt about it. So there is. It is quite clearly an additional qualification added to what is otherwise prescribed in drugs and cosmetics rules. Now, if you watch it, accept the argument that there is an occupied field argument permissible or that there is repugnancy, then the simple answer about this, we must follow Rule 49. My humble submission is that, which is what I'm saying. I'm going one step backwards and saying that the concept of repugnancy or occupied field cannot be applied when you are dealing with two different services. Services under the center, services under the state. See, and the reason why I'm especially saying the concept of occupied field, repugnancy, etc., they work only in the concurrent list. It can't be across lists, which is why in the concurrent list, both have lawmaking power. And therefore, the union's lawmaking power is considered supreme unless I get the concurrence of the president to a particular law changing to the state to avoid this repugnancy. But if I make a law and it's only passed by the governor or it's approved by the governor, if you watch it find this repugnant, it goes. Now, you watch it have that as one principle on one side. Now, please see the power granted to me under the Constitution. Article 309 has Article 309 and a proviso to Article 309. Now, what the proviso is, what is the period between the law made by the state and any rules that the president of the law makes. That transitory period is what is covered in the proviso. But the main provision is 309 itself, Mammal submission case, dictates that the state will make its law to govern services under the state. The center will make
laws with respect to services under the center. And that is recognized by not putting services not in the concurrent list. Services is put in list 1 for the union, in list 2 for the state. So the first submission that I want to make about this, when your lordships are analyzing a rule which pertains to service, your lordships must examine whether the union itself has the power to enact a law which deals with services both under the center and the state. At best, and I would especially say, at best, Rule 49 can only apply to services insofar as the center is concerned. It cannot apply to services under the state. Otherwise, the lordships will be permitting transgression into services by the state, which is covered by this Schedule 7.
There are two aspects. Say for example, like GST. It is again a central law, implementation is at the state level. Similarly, there are certain areas, food safety, right education. All these are central legislation, but implementation is at the state level, by the states. Because implementation of such a humongous project, project of such mammoth proportions, is almost impossible. So that is why you have this duality. And in such a scenario, would it be different to have a uniform stipulation or leave it to the vagaries of the state? So what will happen now? The functions that are being performed by officers of any state are similar. So that is so. Why should there be a fluctuation? Why should a fluctuation be permitted in the qualification that is going to be stipulated? And that, see, if a B farm can perform it, if a BCom BSc student can perform it, why should you? And it's a admittedly entry level post. Why should you insist upon an MSc? Because what happens is when you insist upon MSc, you are eliminating a class of candidates. There is a nexus. If there is an objective, and this criteria which you want to stipulate will help you in achieving that objective, then there's something different. Yes.
The first part is, can you do it? First part is, can you do it? If I can do it, I believe I can do it, then comes the next question of whether that additional qualification you prescribe relevant to something.
No, see, these are special enactments where there is a role for both the state and the center. But the control, if you read, probably if you go to the object, statement of objects of the enactment, you would see that the preamble of the enactment would reflect an intention of the center to retain control, to retain within its grasp the reins of that field. Otherwise, it could lead to difficult situations. And now, comment.
I can't agree with you. There is some logic to the uniform system throughout the country. Every state has the same system which applies to all recruitment. So I can't.
That's why right at the beginning, I asked Mr. I asked you, what is the number of factories,
yes,
number of posts that are available, the number of candidates are available. You see, concentrations would be here and there.
But what you want to say? Correct.
Oh, it's not decided wrongly.
Why I'm saying the reason. Satyapal Reddy provides for section 2 and 3. Right, and 2 and 3 both provide. The central government is going to qualification. Now, and it's all very clear about taking out this qualification. The argument in that case was identical to this. Central government has prescribed qualification, which qualification is applied across all states. Because ultimately, it's not like motivated respect in one state is better than the other. Why one state you prescribe qualification higher than one state government or the central government prescribed?
Nature of job, the nature of the job, where this requires some specialization. Motor vehicle inspector's job may not require that level of. No, it requires
to do the work that they do. But all that is required is
required for the work they are doing, not for the work that they are required to do. That may require something. But what actually they are doing, they may not require it.
And a diploma in mechanical engineering. A diploma in mechanical engineering was the state board of execution. There, Andhra Pradesh said, it is not a diploma, you have a bachelor's degree in engineering. But now I'm not on whether it is good or bad. Maybe good or bad, that's a separate issue. And I'm not only on that question. I'm only on the fundamental question of the logic asking as to whether when the center has prescribed this, and a diploma and a health standard. Here you have a thing which says, I got a bachelor's degree in engineering. Which is of course not much higher for which means you pass PUC also, not just in this PUC and then you've done engineering. So bachelor's degree. Now the question before the Supreme Court was not whether it is good or bad. The question was Satyapal Reddy's case was not whether it is better and we get better people, or whether it is exclusionary.
But Satyapal Reddy again refers to 213. It specifically refers to 213. The powers were vested in the state under 213. There's a specific reference.
But it does not only this. It also sees it does not go into the question of whether these are rules which can be made and exercised for ruling power of the state. Not. As a matter of fact, the only qualification which can be prescribed under the Motor Vehicles Act is by the central government. There is no separate provision which says the state government can make rules separately under the Motor Vehicles Act. But then I ask myself the question: how does the Supreme Court find an answer to this question? It is a question from which on first
Find an answer if you raise a challenge.
Yes, in this case it has been raised, and Supreme Court has find an answer.
There's no challenge by you.
I'm now answering the
State.
State is to be answering really one question, and the biggest concern I have not to do with this. The question of whether my power to prescribe a qualification can be taken away simply because of the law which prescribes a separate qualification enacted by the center.
That's what 254 says. 246 says. 46, sir. You should go through the chronology.
They will also now take Satyapal. They won't read from Karnataka again. Yes. Maybe Public Service Commission and issued a no argument that applies to this. Since there was only qualification of diploma and mechanical engineering, so not pursuing to do. Applicants therefore filed OA number 20 and batch immediately administrative value pursuing the competence of degree in mechanical engineering or degree in automobile engineering or diploma in automobile engineering or any equivalent qualification as conditions for recruitment intending that it was the central government which had been conferred with the power to 234 of legislation that of prescribing a qualification for appointment to any office or class of officer under this act. And it prescribes the following qualifications. Minimum general qualification passes, then diploma in mechanical engineering, diploma in mechanical engineering, or any other qualification created equal the central government. The applicant becomes qualified to apply for and seek recruitment to set for the description of qualification of graduation in mechanical engineering by the state government coming in conflict with the act and superseded. But this is the exact point here. He described the qualification which is different from what was prescribed under Rule 49. The argument was the central government having been the sole repository of the power that is to be exercised so far as this kind of qualification. State law which says something else stands superseding. That is the argument in this case. To dismiss. Then the contention were paragraph 3 and 4 are noted. Now we come to paragraph 5. Having given an initial consideration to the respective intention, we find the case decision then, which is seen under the subject matter section. Section 1 says the state government used for the purpose of carrying this the provisions of design, establish a motor vehicle department and appoint as officers thereof such persons as the things. The power of appointment includes the power to select a fit and competent person who thinks to hold the purse and to discharge efficiently the function assigned under the act. It includes the power to prescribe qualifications to select suitably itself. The Parliament reserved the power of the state government under Section 231 itself, but allowing it to appoint officers who find fit to carry into effect the provisions of the act. But in establishing a motor vehicle department and appointing certain persons does not necessarily mean that you can prescribe qualifications.
Once it is a department, you're required to cadre everything. Here it is the hierarchy is specified under the act. Department, the hierarchy is.
All the hierarchy and officers are appointed in terms of what those. So we also establish in the similar way a department for the state. This is the drugs department and appoint officers to that department. Which is why we have our own cadre and recruitment booths. The Civil Services Act, the Civil Services booth reflect the cadre and recruitment booth, reflect the recruitment of every single officer that we appointed. To ultimately carry out what? To carry out the purposes of drugs and cosmetic science. Therefore, when I recruit within me, within the state, a department created, I still create them to not enforce an act, which is the central act. What I am only pointing out is, while the central act can no doubt confer powers on these officers, who these officers should be, and how these officers should be, and what qualifications they must possess, is a matter which the state determines. Otherwise, the entire rule-making power that I have in terms of this school is not completely obvious. It is not this one act. There are several enactments of the central government which fix their qualification. My qualification may not be the same. My qualifications may be different. In which way, what will happen is every single qualification that the state has prescribed will now have to be read alongside what the center has fixed. And it's not just for one enactment, but there are several enactments. Most of the officers who actually function today will function today in exercise powers which are conferred on them in the central act. But they are a state service. And therefore, the Supreme Court, if you watch it, sees para 7. It does say the Parliament has exclusive power to make law with respect to any matter, innovated in this one, or concurrent power of the state legislation in this of the championship of the function, which shall prevail over the state law in the state legislation, exercising the power on any of the entities in this 3. If the state law is inconsistent or incompatible to occupy the same 3, to that extent the state law can supersede it, become void. If the settled law is in Parliament, the legislature grant the power of Function 2. And the entry to control, whether prior or later to law will be taken. Article 342 gives power to this. What it means are renewable rendering law made by Parliament, it's paramount to the law made by the state, unless the state was reserved. Whether there is ability to Parliament for conflict and justice is not option where the problems of the same thing with respect to one matter anyway is well and where there is accountability involved. After 254 days,
see now this harmony between the two legislations is permissible, like for instance, Motor Vehicle Act, where rule-making power is delegated to the state. So you insisting upon a higher qualification will not in effect take away or negate the provisions. So repugnancy would not arise. But here,
in so far as qualification required for services, that is exclusive within the domain of center and the Motor Vehicle Act. Which is why Supreme Court is otherwise there is no inconsistency. On the reading of the Motor Vehicle Act itself, it becomes clear that
whether you can call this a state service exactly, see, that is the problem. The duality involved in this central enactment, because the standards, the duties to be performed are all prescribed by the Central Act. You cannot depart from those duties. You cannot create new duties. Okay, duties and whatever the objective that is sought to be achieved by the Act is the scope of your can be the scope of your activities. It cannot be beyond that scope. So here, in essence, it is a central function which is discharged by the state. It's essentially the function of the center, which the state is discharged. That is one thing that we'll have to bear in mind. Because the drugs has an impact across the actions in the motor vehicle department may not have an impact on the other state, may not have an impact on the other state. So that is why you have varying tax rates and all this and people rushing to states and union territories to purchase vehicles, all this. But here that is not permissible because it directly has an impact on the Article 21 will be involved life.
there is no authority vested in the state to alter any of the powers that are there. But the powers that are
Here,
are all going to be controlled by the law. It can't be different. Unless I make a new law for my state. If I don't make a law of my state, then I can't have Act 122. The question is already now who do I appoint? The people I appoint, but must draw a distinction between what is occupied in so far as drugs and cosmetics as a lower expense and what is occupied in so far as services of persons who are employed to carry out functions under that act. So this is why I said, if I make the law to drugs and cosmetics law for Karnataka, unless it is reserved for the assembly president, it will become repugnant. So it is law.
So then you'll have to call in question section 33. Yes, because section 33 enables them to provide to make rules. And now when it comes to that once that the power is there to stipulate the minimum conditions in respect of the officers under 21-22, and certainly then you have to.
The entire argument is the fact that section 21.
It's a state service, there be no doubt.
It is a state service. It is recruitment by the state.
Recruitment may be by the state, but it is an implementation of the central act.
There are so many enactments of the center, if you want to see. There are so many enactments of the center, for which department is established on state, which exercise the powers that are conferred on the officer by the central government. But no, difference is now very fixing qualifications. This is what, if I may say so, what is Paragraph 7 of the Supreme Court judgment. How the Supreme Court answers this question with respect to the becomes crucial. Supreme Court says you can prescribe qualification higher than that prescribed by the central government. Now, if you not, in the motor vehicle act, there is no separate provision itself. The state has power to make separate rules for motor vehicle inspectors.
13 permits you to make law. Good mark. Age one. The law on the point is where the intention of the parliament is to exercise control over a particular field. Then the intention of the parliament is supreme. You cannot travel beyond that. You cannot assert a right of the state contrary to that. Unless and until, yes, you go the 254 way.
Every circumstance, responsibility occupied field are principles to apply, except when it comes to service. When it comes to service, then the Lord have two separate lists which deal with the question of service. Service under the center, service under the state. And there are separate entries for it. Otherwise, you would have given concurrent list. You would have given concurrent list, and let us say attachable to each of the laws that have to be made. And the center makes a law, automatically all services under that law will come under concurrent list. It is not so, it is under the state list. We see what the state government has power under 213. 213(1) says state government may be the carrying the provision to do that, establish a motor vehicles department, and appoint the officers thereof such persons as will fit. Every such officer will be a officer. And 3, state government may make rules to regulate the discharge by officers of the motor vehicles department of the function and in particular without prejudice to generality of the foregoing powers of the system uniform to rule authorities which may be subordinate, duties to perform powers to be exercised, and the conditions governing the exercise of such powers. So please see 4. The central government may, having regard to the objects of the act, by notification of the describe the minimum qualification which the said officers of any class thereof shall possess for being appointed as such. In addition to the powers that we confer on any officer of the motor vehicle department, such officer as the officer will come to the powers will be seen. Then the power of the central government to be used as 215C. You should now see the difference in the language in the power of the central government to make use and the power of the state government to make use. 215C and 215C. 215C, the Lord says. 215C.
Yes, yes. I have time. Yes. Yeah. No problem. No problem. No. Proceed.
215C. 2C. Without creating generality, such rules will provide minimum qualifications to the department officer or any such class thereof shall be required to possess appointment as such. Which is established here. The fact that I have the power to create a department necessarily presupposes that I have the power to also prescribe the qualification that I want in my department. Which is why in ultimately the Supreme Court refers to Article 309 of the Constitution and wrote this and takes the finding. What was done by the central government? Let's read that. What was done by the central government? Only the prescriptive minimum quality. Leaving the point open to the state government itself to prescribe high system, higher qualification. The government has been given power under proviso to Article 309 of the Constitution, subject to uniform legislation, to make rules regulating the recruitment, which includes prescription of qualifications for appointment to an office or post under the state. Since the transport department under the Act is constituted by the state government, and the officers appointed to those posts belong to the state service, while appointing its own officers, the state government has a necessary adjunct is entitled to prescribe qualifications for recruitment or conditions of service. But while so prescribing, the state government may accept the qualification or prescribe higher qualification. But this government submission has, according to me, been consistently followed. In Saroja Devi's case, which you also saw, nursing council, they are also not in the prescription of qualification. The argument also is identical to the way it is.
That's slightly different, like Motor Vehicles Act. There is no prohibition, and the role of the INC is restrictive law.
The question there was only ultimately, I'm trying to see how to analyze this.
Yes, yes.
Supreme Court went to 309, accepted the power of the state to prescribe a qualification, found that one particular qualification is what is required in the Nursing Council Act and the regulation made around that. Uttarakhand had prescribed a different qualification. Supreme Court said, do not interfere with it, because that is a qualification. Now, which was also the case with the other judgment, the NCT Act and Mr. Vallabh pointed out, they were Uttarakhand department. Where again, this is the same question arose. NCT has prescribed a qualification and the state prescribed a different one. Supreme Court said it can be done. Now, one last judgment. Where my attendance has.
No complaint.
Last judgment, I think, Article 309. The question there was when the state has made an enactment, can these transitory provisions in the proviso of 309? Once the rules are made, can the government then make or issue any other rules different or contrary to that? That is the question which arose in that. That is not one of the questions that arises in market. This is really center state issues where the state has within its own sphere legislative supremacy.
Correct. See, the problem is how we will have to fall back on the rules of interpretation governing Article 246, 254. They what the apex court has held, that would that would be the path we should tread on.
Which one?
See, you may do it with the noblest of intention, but intention would not legalize.
So far, this is concerned. Ultimately, but what I'm humbly submitting is what is examined. I am passing you. I only request what to and there one fact in mind.
No, that we understood.
And that will that what is repugnant is the enactment of the Working Property Act. The prescription, because what they can be right by legislation, one which is referred with many entries. The main entry which is referred in this case, which is drugs and possibilities. When lordships are examining drugs and possibilities as an enactment, these services not created, they don't come under drugs and possibilities act. The services don't have to be referred to some other entity, either in list 1, list 2, or list 3. Services not in the center prescribed will always be referred to list 1. Because in so far as services are concerned, there is not something which is reckoned under the drugs and possibilities act. Therefore, there could be many entries which it deals with. Therefore, the best possible interpretation in order to avoid any inconsistency can only be that Rule 49 is also an exercise of the power of the central government and list 1 to apply qualifications for its own services, but not for the service under the state. This may not have a humbly subject in the judgment of A.D. Krishna's case is also covered to some extent. Para 6 and 7. Raise comparison. Last judgment of the base comparison starts at page 105. Can you just go to para 5, 6, and 7? Making power to provide services under the Union of State are vested in the as a case under Article 309, which provides I won't talk about it. Para 6.
I'm not sure.
Para 6. It is primary with the legislature. Para 6. Primarily, the legislature in the parliament or the state legislative assembly who power to make law regulating recruitment and completion of service of persons appointed to public services and posts in connection with the affairs of the union or the state is vested. Legislative field indicated in this article is the same as indicated in NT 1 of this one, NT 71 of this one of the 7th schedule, or NT 41 of this 2 of that schedule. The only two entities which are referred to services. The proviso, however, gives power to the president or the governor to make services, but there is a transitional provision as the power under proviso can be exercised only so long as the legislature does not make an act whereby recruitment to public posts as other conditions of service relating to that post are laid down. The rule making power under the proviso to Article 309 is a legislative function. The 309 has to operate subject to other provisions of the Constitution. It is obvious that whether it is an act made by Parliament or the state legislature, which lays down the conditions of service, or it is a rule made by the President of the Government and provides of the has to be in conformity with the other provisions in the Article 16. Therefore, my respected submission is that the legislative power with respect to services and not with respect to the qualification have to be referable either to NT 71 of this one or NT 41 of this one. Drugs and cosmetics does not really impeach service. You make a law without which could be the point to do something. Now, if you are creating a service, then what this has to be referable to one of the entities in this one of this. When it comes to this, the only requirement that I must fulfill is that I must follow the qualifications that has been raised as a matter of good practice, but also ensure that I don't deviate from it by prescribing something more. It has to be something higher. That will not be humble solution. This is the best way in which the Supreme Court has dealt with the scenario to ensure that the state's powers under its enactment is not in any way dwindled or belittled by an enactment of the central.
In case my lords are like to accept the submission. Be contained. Administrative tribunal where RIA watch the rejection notice and directly that the claims of the applicants for selection goes to the drug inspector be considered without applying the experience as well. That went all the way to the Supreme Court.
Finish it. You're still young. If anybody has to complain, it is us.
Yes, I still because
Just said 15 minutes. We are willing to give you that 15 minutes.
yes, it takes more space because
What is it that you want to submit or what?
I just have some
What additional records? Kodi adyan one nimcha adu kya karte din Then additional records kodi. I don't think it will require 15 minutes or not. It's a matter of records.
Before I come to page number 1, page number 7. So what I will place on record. Page number 7.
Yes.
That is the official memorandum. Page number 7 is the official memorandum dated 14/11/2019. Where constituted those 3 teams for the purpose of verification. Now kindly see, we had 3 under 1, under 2, under 3. It consists of 2 officials of the KPSC and then we see them number 3. What should the name of the so there are 3 people. 20 members of the verification committee.
This by inducting outsiders, are you not compromising the sanctity of the process? Because it is not required. Now, who is at what rank, who is at what position, who is moving up, who is moving down, everything becomes public. And see, 1 minute, and 1 minute, 1 minute. And these people are an affinity to the department. How could you lose sight of it? And their own colleagues and co-workers are here. Their subordinates and others. They are also part of the race. See, that is why your role should not have extended to that beyond the verifying the genuineness of the certificates. But you went beyond that. Getting these inspectors it was for you to verify whether 1, 2, 3 certificates are placed along with the application. Once that was done, then all that you were required to do is call him, consider him and forward him. If he was found ineligible, they will reject him and send it back to you. You will call for another second additionally. Law provides for the alternative. You want to assume a jurisdiction which was not with you. Why did you want to take on a duty that is not visualized by the Act?
What we have done is only verification. We have not gone into evaluation.
You have gone into evaluation. You have said this certificate is this. This certificate merits consideration. This certificate does not merit consideration. No, that you cannot do. All you were required to see, that is for the employer. He is the expert. He is the expert. You are not the expert.
They have not given a certificate.
Your expert could have been only per person who knows BSc chemistry.
They have given a certificate stating, not stating that the qualification.
Whether there is a certificate or not. All that you are required, whether it speaks of training, it speaks of experience. If there is a certificate which does not speak about experience and you reject it, it's a different issue. You have not done that. You have assessed that experience. You have said this experience is in R&D, this experience is in manufacture, this experience is in R&D in manufacture. Don't do that. That is not your job. You are not the expert. The department, the employer is the expert. They have the expertise to adjudicate that. They can call upon the candidate. They will give an opportunity to it. Here, your rejection is, see, you just go to page 1 to 6. It will show you the arbitrariness. Go to page 1 to 6. Considered by central expert, considered by state expert. It's not arbitrary. It will not be arbitrary.
submission on this, sir. That's why my
Yes.
sir, must give me some time. Please, must pay.
These aspects,
Next page number 9 for a moment. Page number 9.
see, this is an act that is done. This is an act that is done. There is question, no you, question of you justifying. Show us the law which enables you to evaluate the certificate.
I'm not evaluating, sir.
You may say so, but in our opinion, it is an evaluation.
What is the opinion? What has done is an evaluation. On the basis of records placed before the court, I cannot dispute that fact. But I'm trying to submission that I'm trying to put is for my lords is that we have not gone into any additional material for the purpose of evaluation. The certificate that was placed before the first the state expert was considered by him, he has given his opinion. Then the lords, we have had the central expert, he has given his opinion. And finally, the lords is considered the opinions and finally I just wanted to show that how we have come to the conclusion. And before I go to that, I also referring to the fact that you worked with the state expert have that their own employees were part of the recruitment process. Can you see page number 9? Can you see page number 9? On the first day.
This list also is incomplete.
The entire list of 70 candidates who are finally called.
Correct. Some candidates have been assessed by the board, some candidates by the committee expert, the 2-member committee of the subcommittee. ಅದೆಲ್ಲ ಎಲ್ಲಿ ಇಲ್ವಲ್ಲ ಬೇಡ that whatever records are there in our possession will explain all that.
If there is any incongruity in understanding the record, and if the finding is there again, I give you some time to explain this because this is a statement that was declared for the purpose of showing the final list of candidates who are found to be eligible. Because this is a list of 70 candidates.
Whoever states who are the candidates that have been assessed by the 2-member experts of the board, and who are then some of the candidates who have been assessed by the board itself. You have accepted the recommendations of the 2-member committee.
I just show you the 2-member committee was that day was when we get the records. I went to the 2-member committee. I have checked it up with this 2-member committee was talking about around 20-30 candidates. In that, there are only 3 candidates who are in this list. The rest of the candidates have not been considered as eligible. Those things I wanted to clarify. Otherwise, what happens? So far as
See, all that is the problem. That is the arbitrariness. Understood? That is the arbitrariness. You can't apply one standard for candidate A, another standard for candidate B, another standard for candidate C, and another candidate for standard candidate B. That is what you have done. One candidate on the basis of central expert, one candidate based on the state expert, one candidate on the basis of central and state expert, one candidate based on the recommendation of the subcommittee, and some candidate on the strength of the decision of the board. Where is the commonality in all this?
every candidate is assessed by all of them. The only thing is with regard to one exception, there was some confusion.
In-service candidates have not been assessed at all.
That is not the correct position because in-service candidates, what happened was kindly see was based on the time for a moment. I asked for
who is the DDC?
DDC is the deputy president. I'll just explain what happened.
Oh, who is this state expert?
State experts are assistant controllers. The persons who are deputed
So state expert is ADC.
State expert is 80. The three people who came out.
For in-service candidate, it is DDC.
Because there is
Then who is the central expert? ಎಲ್ಲಿಂದ ರೀ ಬಂತು?
These assistant of the central government. Those three persons who came, we had taken a declaration from them. And this is a declaration.
Not enough. What more is required? On facts, what more is required to set aside? This fact, this short fact is sufficient.
I'll just put it this way. I'll explain this already now.
You can't see, you can't go beyond the records.
So far as anticipation of time.
When arbitrariness is manifest in pages 1 to 6 itself, no other record is required.
I'll explain 1 to 6 months.
Can't explain. Can't explain.
I will place this on
Please
record.
tell me, one person will be assessed by the DDC, one person by ADC, one person by the two-member committee, was one person by the was that your board,
All the three.
then one person central committee. What is this?
All the candidates are chosen by all of them, except Mallard's in Zoma's himself is candidate by the ADC. ADC Mallard's, because he could not do that, we have got it done with ADC.
Records before the court, clearly there is an endorsement not verified.
I mean, this is the first page my lords have seen.
Not only first page, in several pages we have seen.
I will just ADC Mallard's that day, we passed on the record. We did not have a problem.
Even if with regard to one candidate, if the process has faltered, it has faltered.
ADC Mallard's, I will just this record what is.
There is an endorsement in service candidate not verified because of instructions. DDC opinion by the
Not verified as per the instructions as a candidate, so that's because they gave a declaration that we cannot go the whole.
You know, why should they be assessed by DDC?
Because he is a superior officer.
Why do you want a superior officer? It should be only one person. You can't have different yardsticks. What was the necessity for a different yardstick? What is the necessity for a different yardstick?
They gave declaration that ADCs could not.
Why ADCs can't assess that certificate?
I asked them for a declaration. ADC page number 9.
Where is the declaration in your notification?
Declaration number that was given.
Where is such provision in the notification?
ADC page 9 for.
Go, please. It was in the notification that you have treated them as a separate class, or you have stipulated any separate criterion for them. If you can't show, don't try to explain. It is a futile exercise.
So far as in-service candidate, because the three ADCs who had come, they had to give a declaration that no candidate known to them first, they will assess. So when we came to know first that in-service candidates, they immediately informed us. He said no ADC.
How do you know? How did you come to know that these ADCs are known to the in-service candidates?
ADC informed us. That is ADC informed us. That is the declaration they have given. ADC. That's why Lord's ADC page number 9. No, plus 230 plus all respect. What has happened? I asked them.
What more do we require to set aside this? Anything more than this statement? I am assessed by a person who is known acquaintance of my competitor.
I am not been assessed. Because that is only on the basis of the.
So this is the transparency you have practiced.
That is an input to me.
It's a pass.
I cannot get them from mass notes with all due respect. I have to get it from
No, you should have sent it. You should have selected and sent them to the department, employer. You need not have gone to Mars. You need not have gone to Mars. That is not your mandate. That is not your mandate. Don't exceed your mandate.
So far as I have to get some experts. They got it from the State Department.
Why do you require experts? Employees are not experts in their field of work. Are they experts in their field of work or not? Then what is your business to intrude there? Why? Some other calculations? Yes, certainly. This itself is sufficient. Don't push us further to observe. Yes. Don't try to justify this. You will appoint one person to examine me. One per A, then another person for B. What is this? You should have brought in a neutral person. You can't now come and say we appointed DDC because ADC is known to the other competitors. It is not him favoring them by selecting them. He will be favoring them by rejecting our candidature, and that is what has happened. Central expert. You have not remained by the central expert. Those who have been rejected by the central expert have find a place here.
Central expert, what he did was, he assessed it as C and C1 instead of C and C1 and C1. That decision was taken by the commission to make it C and C1. And then we have come by any doctors who have been candidates for that. And finally, notes I found them 70 people eligible. And I went to them. It is not, this will affect the merit.
You don't even disclose the material. You don't even disclose the material that has been put against them. This principles of national justice is not necessary. Everything will be cloak and dagger, and I'll have to be permitted to carry on with it. Question now, that is not a license for you to do it in an arbitrary fashion. If your say so, that doesn't suffice it. Whether it is arbitrary or not, both of us will have to say. We have given you, we have been hearing you, we have given you. Come to page 6. Come to page 6. No clarity given, not verified, not recommended. Kendra Tagnara Prakara in the Irvadinda Pariganichide. Money considered by central expert. How can you have that such different yardsticks? See, one the process should be transparent. Transparency is not just revealing everything. At least the manner, like they say, it is not enough if justice is done. It should appear to be done. It is not enough if you give a final select. That final select should at least reflect true merit, at least to a large extent. There may be a slip up here, a slip up there. We don't attribute motives, but not in this fashion. I call state expert for you. I'll call central expert for you. Then I will appoint one subcommittee for you. I will then the whole board will take up the case of you. Okay, show me from this list where is the reflection of consideration by the board. I asked you on day 1 itself. Happy had you done so.
I'll just take one example. Last page, page number, just to serial number 171, last page. Other serial page number 6. Serial number 171. This serial number is actually referred to the records numbers that was already placed on the record. Now, can you see register number? Whether insurance candidate from the department is not, then it was recommended by the state expert. But your central expert did not recommend it. So can you see what's the shara? This is what happened.
See, drug control, no clarity given, considered by central expert. How do you explain? Serial number 170, no, serial number 170. No clarity given, considered by central expert. What is this?
The opinion that they gave, there was no clarity.
Who gave an opinion?
The state person. That is the obligation of mine by us. We have checked up each of their opinions. If they are not satisfied with them, I am not taking that because it is an input to me. That's what Supreme Court said to the see words of Justice Krishna. It is an input. If I have to consider it. I cannot abdicate because of my responsibility. By just going with experts, I have to consider this opinion as an input.
Serial number 199. No clarity given, no clarity given. State ಕೊಟ್ಟಿಲ್ಲ, central ಕೊಟ್ಟಿಲ್ಲ. ಇವರ ಸೇವಾನುಭವ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳ ಪ್ರಕಾರ ಇರುವುದರಿಂದ ಪರಿಗಣಿಸಿದೆ. ಯಾರು?
Commission is finally done.
No, commission has become expert. When you are an expert, why did you invite state and central? Why you required one more two-member expert? You get a 3-member state expert, single man central expert, then commission expert. One too many experts. So which expert are we to follow? There are no bona fide. Don't force us to say so. We don't want to say so.
Complaints, so I have placed it. There were several complaints. I also placed our management.
Complaint verify madadra. ಯಾವ complaint? Go to the complaint.
Page 45. Page 45, yeah. Just do the list. Yeah, they said that what they are saying is there's no specific complaint against a particular individual.
Yeah, that is some. See, now read the page 167. I am a practicing physician and I have worked in many clinics and hospitals to say they're all run by either Lent certificates. I don't know what it is. But also there must be candidates, pharmacy graduates, Lent their certificates to open pharma outlet and get their commission. I believe these are unethical and these type of candidates should be prevented from becoming drug inspector or holding. What is this complaint? Tell us. In complaint igo, ನೀವು ಮಾಡ್ತಾ ಇರೋ process igo ಸಂಬಂಧ ಏನಾರು ಇದೆಯಾ? Not fake certificate. This is name lending exercise. What they do is, those who have this B-Farm course, they will lend their name for a person who will open a pharmaceutical store and run the business. He will be paid certain royalty. ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ? ಏನಿದೆ ತೋರಿಸಿ ಕಂಪ್ಲೇಂಟ್. For you to call this expert, that expert, show me one complaint which justifies their. ಯಾರಿದು? ಫ್ರಮ್ ನಿಸಾರ್ ಚಬ್ಬಿ, ಸಂಪಂಗಿರಾಮ್ ನಗರ್, RR ಜನ್ನು, ಏನು ಆಮೇಲೆ ಕೃಷ್ಣ ಬಾಜ್ಪಾಯಿ. This is, they are the recipients. Now go to the previous page. RR Jannu, Krishna Bajpai. Next. Now come to this. I got information that there is a process of so and so. I am also running a pharmacy shop. Okay. My concern here is that there are many aspirants who have got fake experience certificate, experience letters. Yeah. One more, there are many candidates who lent their pharmacist registration license to others to run a pharmacy shop. Next. Next. By name bartave. That is the noticeable aspect of these complaints is they are all addressed by name. I mean, the recipient is addressed by name. Normally, you address to the office. But despite they being recipients and the complaints being addressed, their personal name, none of them have taken any action. Very unfortunate. Fell on the commission to take action. See the language. See the language of the complaint. You want us to say something? No, you want us to say, we will say on these complaints also. No, you want us to say on these complaints, we will say. The complainant is a ghost in your office. The complainant, okay, is a ghost in your office. You want us to explain that concept? You got it? You got it. You want us to say something more? You say, we will say. These are complaints that have been got up for you to do that exercise. It was an excuse for you. Not go into that. If you want us to go, we'll go. Yes, third reserve. Your committee is not actually required.
Make a submission, my lord.
There's any urgency.
Serial number 47, my lord. Yes, my lord.
What is the urgency? Lala. They'll come for that. Wait, tomorrow. Nala, tomorrow.
Madam, on the final disposal on the short date, madam. 47, madam.